morning,
Good morning.
everybody. Good morning, Herwig. Nice seeing you online, but still it's good enough. It would have been ideal to see you here. It is my pleasure to open this roundtable today on current developments and challenges in EU administrative law. My name is Florin Comancun, and I'm a senior expert on EU governance at the European Institute of Public Administration here in Maastricht, but also I'm working, let's say, as an associate professor on EU law at Erasmus University, Rotterdam. But here I'm mostly in my quality as senior expert in EU governance. Let me just perhaps start with a brief introduction before opening the first panel. First of all, I want to thank all the speakers, for all the participants in the room here. From actually the EU institutions, we have the European Commission, we have the European Parliament, we have the European Ombudsman, and it's nice mix because we have on the one side the institutional side of expertise in this field, but also we match this with the academic side. And here we have experts from Maastricht University, from Leiden University, from Utrecht University, and if you want, also I'm also here in my double-headed capacity in a way, also as an academic, part-time academic, so to say. Now, the aim of this roundtable discussion is to basically, let's say, if you want to map and discuss some of the, let's say, latest developments and challenges in EU administrative law. We know that, let's say, at least on the let's say legislative side, let's say things are not moving or are not advancing tremendously in the field of, let's say, EU administrative procedural standards or substantive standards. There have been already, I think, some 10 years ago, some initiatives to adopt common rules, some sort of uniform rules on EU administrative procedure. Some of them coming from the European Parliament, others coming from, let's say, perhaps slightly different initiatives, such as the Research Network on EU Administrative Law, the Renewal Project, that also put forward certain model rules on EU administrative procedure. But, some time already passed in the meanwhile, so it's been like more or less 10 years ago. And then I think we are here a bit to see where we stand now in terms of evolution, challenges in EU administrative law. So basically, this is the aim of this event today. We have two panels, until lunchtime, 12:30 more or less, another panel in the afternoon, starting from 2 o'clock till 3:30. And basically, let's say the format is as follows, more or less. We have short, let's say, statements by the speakers in each particular panel. Let's say the time, let's say, for the statement would be, we indicated somewhere between 10 and 15 minutes, but I would encourage the speakers as much as possible to allow enough room for discussions and exchanges, perhaps to deliver a statement up to 10 minutes, if possible, of course. Then after each statement, we will have, short, let's say, question time of about 5 minutes to address any fresh and, immediate reactions to the statement. And then at the end of the panel, after all speakers presented their presentations, then we'll have another, at least, let's say, 10-15 minutes to address any remaining questions concerning all the interventions. And perhaps one last thing in terms of the aim of this event. This event, in a way, is also, let's say, preparing the field, and it's in a way an opening event for what EPA is preparing now. Let's say in terms of a training module on EU administrative law. This is meant to be a bit of a comprehensive horizontal module covering different topics such as structures, procedures, actors, remedies and legal protection, procedural rights, and basically, let's say, with this event, we basically, in a way, let's say, try to, and actually we open this kind of, EU administrative law module, and basically the concrete trainings are planned to be launched later this year. And most likely, well, we envisage to have the first two modules, actually, one on procedures in EU administrative law and the other one on the right to good administration and procedural rights, to be launched for the first time after summer. And of course, your insights and perhaps also your future involvement in such trainings will be actually, well, also one of the perhaps let's say takeovers from this particular event. I stop now here, and well, I pass without further ado the floor to my colleague Diego, who will also moderate panel 1.
Thank you so much, Florin. My name is indeed Diego Ramirez Cárdenas Díaz, to be complete, and I'm senior lecturer at EIPA Luxembourg. For those who don't know EIPA that well, EIPA has its headquarters here in Maastricht, where we are located, and all matters related to EU law are run by the branch of EIPA, which is located in Luxembourg. Indeed, together with Florin, I run the pole of competence in EIPA relating to EU administrative law. And today I have been assigned the role of master of ceremony, or rather the chair of the two panels. And as Florin has said, EU administrative law is very much a living being, a substance which has developed, grown and changed exponentially over the years. This is why when Florin and I were somehow coming up with a structure for this day on EU administrative law, we said that there should be imperatively two panels. A first panel dealing with current developments, and this is what we are going to do right before lunch, and a second panel dealing with challenges, that is the outlook, the future perspectives. So then let's start with the very first panel, current developments, and then you will be seeing that in order to deal with these substantive matters, I'm not here on my own. I'm going to be accompanied for every respective panel by 4 leading specialists on the area. And to begin with, for me, it's always a great pleasure to salute and to greet Herwig, Dr. Herwig Hoffmann, even if this time is in the distance. Hello, Hoffmann. Hello, Herwig. And Herwig is going to put the conference today on the right mood, because you're going to introduce the matter presenting an outlook to the current status quo on EU administrative law. The titles and merits of Herwig Hoffmann are very numerous, but simply I would mention over here that Herwig at the moment is Professor of European and Transnational Public Law and the head of the Department of Law at the University of Luxembourg. As we have said, hello from Maastricht. Herwig, the floor is yours.
Very good morning to you all. I unfortunately have to start this morning with very sad news. I don't know whether you've heard, but my friend and colleague and co-author Alexander Türk has passed away. And that's, of course, on my mind this morning, having received the news yesterday evening. And so when I talk now about developments in administrative law, just want to mention that a lot of thinking over the years of how things are developing has evolved in discussions with my friend Alexander. So what I would like to say this morning about where major developments of European administrative law are moving to is, I'm sure, and what I could see from the overview, tying in with what many of you are going to talk about. And I think it's good to focus on certain matters. And most of it has to do with an ongoing complexification of administrative law and procedures in the European Union, not necessarily always to the best. So just take, in order to get a feeling for what's going on, the field of digital legislation of the last few years. We have seen, including the GDPR and other acts, now in the last 10 years, about 130 legislative acts created in the field of digitalization. So both horizontal, so like the GDPR applicable across policy areas, or of course the GDPR is equivalent for EU institutions, at the AI Act, we will hear later on more about that, but also policy-specific ones, which however have administrative elements. And there are two major developments in this legislation, which I would using as point of analysis to look at broader aspects. One is there's an increasing focus on matters of information sharing, information management, information processing. So what I want to say with that is that information itself is becoming a topos of administrative law in an ever more prominent way. Of course, already in 1996, Schmidt-Assmann famously proclaimed that European administrative law is largely information law, and he was not totally wrong with that. I think he was quite onto something. But we're seeing many of these developments, especially in the digital field. And the other is that we see a proliferation of an increasing complexity of composite procedures in these fields with new bodies and actors, especially bodies, not necessarily formalized agencies, complex interlinking of different levels from these new bodies over standardization, formal and informal standardization forms, self-regulation, and so on. So this is what I would, these two major points I would like to make: information and complexity of composite procedures. If you click on the next slide, please. Thank you. This is an overview from an assistant from the European Parliament, Kai Zenner, who works with Axel Voss, one of the MEPs who is quite active in the trilogues and around digital legislation, outlining essentially what looks a bit like the periodic table of the elements. These are 122 of the now many more digital pieces of legislation in the European Union, just to give you a visual impression of this increase and complexification. If you go to the next slide, please. Information as a regulatory topos. So I was saying one of the major developments is this, over the years, increase of focus on information. And many acts impose information sharing and information collecting and information processing obligations in ever more granular ways. And so if we want to understand what's going on, we have to see that administrative law is not just obliging, so European administrative law is not just obliging individuals to provide and share certain types of information in a, say, B2G, so business to government relation, but also increasingly as regulatory tool between a business to business and business to consumer, or individual, if you'd rather have that word, which I think is better in the public terms, relations. And when we look through the legislative acts, those are not just reporting obligations. So we have ongoing reporting obligations, of course, since the 1970s in VAT issues. And from the VAT, we know that this has become digitalized. And the information exchange has become digitalized, not just between individuals and the government, but also between different government bodies, and that is obviously necessary. Anyone who's followed VAT scandals and criminal rings will understand why. But this obligation you find across policy areas. You find it in GDPR, you find it in the AI Act, you find it in various relations of who needs to collect and who needs to share and make available which data. And that kind of data and information obligation goes up and down. It goes, when you think of product safety and product liability, supply chain obligations are in one direction now, subject to information. And this is a big debate in the moment of administrative burden reduction. On the other hand, you have the same when you think about GDPR. Essentially, individuals need to know where their data is, and companies need to be able to tell them where their data is and how it is being processed, all the way to obligations on international data transfers outside of the Union. Now, whether these are always perfectly complied with or not is another question, but these obligations are being introduced. And you find similar obligations being introduced through the AI Act and through many other pieces of legislation, policy specific as well as general. And the glue which is supposed to hold this all together is interoperability. So we have a lot of new legislative work on interoperability, on how to handle data and information in this context of information sharing, but also, again, this is between levels. It's not just business government, it's also business business or individuals to business and so on. So these debates about new data spaces, for example, in the health field and in other areas, is exactly that. It's about the handling and management of information, which is then a tool for regulatory either intervention or, without any necessary further intervention, already regulatory steering of individual behavior by the requirements of which kind of information is provided in which way. So it's once you see it as such, you see this proliferation of this approach going all the way through. And rereading Schmidt-Assmann from '96 is actually quite informative as to the various information relations which he had already outlined there, which we have seen spiraling ever since. Now, there's a lot of questions open as to what has actually been done with these data, what is happening. And there's a lot of complaints, for example, in the tax field, that incredibly burdensome information sharing has to take place without administrative bodies in the European Union being able to handle this data mass. And so there is a bit of a gap and a lot of questions. So if you go on to the next slide, please. Thank you. And that goes to the second big development I was trying to deduct for the development of European administrative law when looking at the example field of digital legislation in the area of, in these 130 roughly legislative acts, which both horizontally and vertically in certain policy fields address digitalization. Because what we see here is something we will be discussing, of course, during the day now, but I think in the area of digital legislation, quite pronounced. We see more and more a layered approach with new administrative bodies. So most of the new digital acts have created some kind of body, be it in the Digital Markets Act, be it in the Digital Services Act, and so on. And these bodies are not agencies. They are usually either, as we have known in the field of energy or other areas, basically assemblies of national regulators which exchange. And the European Data Protection Board, I think, under the GDPR, is one of the very good examples which has proliferated around the digital legislation. So we're seeing a move away from the formal administrative agency model as an independent legal person towards the model of these bodies, which are composed of various actors of the field, in some areas only national regulators, in others plus cooperation of stakeholders. So it's actually quite astonishing to see, because it feels a little bit like in the period before the first comitology decision of 1986-87, where there is simply throughout legislation a proliferation of bodies and procedures, of course, associated with new bodies, which are being created, and each legislative act has its own, and it's very difficult to keep an overview over which kind of structures and which kind of bodies are being created. Fascinatingly, when you look at the legislation in the digital field, you see another trend, which then once recognized can be seen throughout legal systems, which is that there are diverse forms of co-regulation by standardization being rolled out. And by standardization, I mean not only standardization through the area of the classic standardization, or I say classic standardization, under the standardization regulation with CEN, CENELEC, and ETSI and other bodies being authorized to and mandated to formulate standards, and they being then integrated into EU law again. But also what we see is we see some of that, but beyond that, we see an immense proliferation of what I would call atypical standardization procedures, where the Commission sets out standards together with certain stakeholders, or where you have all kinds of different standardization structures being involved. And again, one of the remarkable things is this proliferation of types of procedures to establish acts of some kind of normative content, and even that normative content differs then according to standards and legislative acts. What is fascinating in this area is, of course, to see that the justification for this diversity is, well, we need to adapt to the different areas of policies and the different types of players and who has knowledge. But when you look at it more closely, the absence of standardized procedures means that there's power play involved. Think of digital regulation. Think of the fact that we are having an increasing oligopolization of markets, big players being involved in rolling out software suites which are applied everywhere. Think of how many universities, just as one example, have moved towards standardized, either Google or Microsoft-based software suites. You see the same in government agencies and offices. You see the same in the private industry. And so having these big players having a specific role because of the procedures which have been set up shows a little bit that we should not be naive about what's going on. This is clearly a question of power being developed. Interestingly, another phenomenon we then see in this when looking at digital legislation is that the implementation is, if you think of public enforcement of the different obligations and rights, is being developed in ever more complex composite procedures. The GDPR already was a infamous example, I think, and if we follow what's been going on in GDPR enforcement in the last few years, for example, with regard to complaint handling, a really problematic setup of highly complex composite procedures. Unfortunately, that was not used as an example to deter legislators from moving down that direction. No, actually, the DSA had received many of those elements. Currently, there's a trilogue going on the GDPR procedural regulation, which instead of simplifying things, adds many more complexities and layers of complexities, unnecessarily so. When you look at other policy acts in the field of digital legislation, it's quite concerning how there seems to be an unawareness on the side of the legislator, and most likely on the side within the Commission and those drafting legislation, as to the detrimental effects of the increasing complexity and the increasing blockage out of ultra complex composite procedures. And the last point I would want to mention when looking at where does this digital legislation take us to in the moment is that we also have a proliferation of self-regulation, self-assessment, and private certification regimes. Interestingly, when you look at, for example, the GDPR or the AI Act, you have the instrument of impact assessment, which was developed initially as a public tool for legislative impact assessment, regulatory impact assessment, coming from environmental impact assessment originally, being rolled out as an obligation to private actors to have a data protection impact assessment, having a high-risk AI systems impact assessment, and so on. Now, there's in principle nothing negative about it. The question is what is being done with it? Because when you look at what actually then happens with these assessments, is that you see the enforcement regime is trying to privatize enforcement by asking then a evaluation through certification bodies of compliance with the self-assessment and these various levels of standards I've been talking about. And you see thereby a once you take a step back, you see a proliferation of private rulemaking through standardization. and then a proliferation of self-assessment as to compliance with those private rules. And when you take that together, you know, what these four elements I'm just describing here, what you see is a proliferation of atypical administrative bodies. You see an increase of layers. So you have already incredible amounts of legislation, plus then, of course, delegated and implementing acts, plus private standards, plus probably guidelines as to interpretation, as we see in many areas. So highly complex sets of rules. But on the other hand, you see inflicting harm on public enforcement through overly complex procedures which get stuck in multiple levels. And then instead of enforcement through private parties, through, for example, allowing for private enforcement of individuals who are affected by these activities, you see the possibility of self-regulation of the companies themselves through self-assessment of their impact assessments and certification through private bodies, which the private parties pay themselves, which also is, of course, prone to interest conflicts and problems. So what I'm painting here is a picture which is, we could say as administrative law scholars, wonderful, lots of things to debate because lots of things are going wrong. That might be cynical. I would say what we are seeing is possibly an attempt to legislate in a field which is developing and trying various types of regulatory tools all at the same time. So we have a highly experimentalist approach to this legislation for putting together the tools out of the toolbox we have. And unfortunately, my observation from looking at various legislative procedures up close, and I was able to look at the Data Act and Data Governance Act and the GDPR procedural regulation a little closer, I fear that there is a total lack of awareness of the problems which come out of this ultimate complexification which we are seeing in this field.
I think we are running out of time, so I would invite you to maybe to reach your conclusions, please, so that
I am there. I've just concluded.
Yes, concluded. Okay, because we are still stuck on page number 2, but then
yes. Well, that was the 3. Yes, if you go to 3, I can tell you this was what I was just saying as the last one. Sorry, I forgot to
the page thing.
Yeah.
Thank you so much. Again, there's no better way to start a conference, an event of this type, with your presentation. Thank you very much. It has been very insightful. And then I would retain the number of keywords that you have pronounced all along your intervention: self-regulation, interoperability standards, standardization, information management. And I would say every one of these keywords would merit a separate explanation. But we are going to stay here, and then immediately we are going to open the floor for questions. All our participants are intervening online, and you are aware that you can either drop your questions by the chat pad, and I suppose that they can open their microphones as well and intervene. Okay, so therefore, dear participants, the floor is yours, and I see a couple of familiar faces on the screen, so you are very much welcome to intervene, please. Okay, so we have a colleague which is running the chat, so maybe our colleague who runs the chat, maybe have you noticed any question which has been dropped there?
Yes, we have one question, and then we also have not a question but an observation from someone, from Miss Desislava. She would like to observe that the GDPR should not be presented as a barrier or an obstacle. And then she thanks everyone for the informative presentation, and the professor especially.
Thanks to you, Desislava, for this remark, and then maybe Beatrice, we can now move to the question.
Yes. So the first question is, with the enactment of approximately 130 legislative acts in the digital domain, how does the EU ensure coherence and avoid regulatory fragmentation across member states?
Okay. Rick, that was the question. Maybe up to you to respond.
Yes. Well, this is, first of all, to the first remark. No, I was not trying to paint the GDPR as barrier or obstacle to development of administrative law or development of business practices. I'm pointing out the difficulties out of procedural questions of enforcement and the complexity which the Article 55 and following, in the GDPR provide for. One can see it with many complaints of high-level nature, which are not advancing, even not just of individuals, but of organizations such as the Bureau Européen des Consommateurs, BEUC, which has since many years a complaint going on Google's transfer of data across the world in quite blatant violation of GDPR provisions, and nothing is happening. Or Max Schrem's complaint of 2013, which is still not solved, and so on. So one can go through many examples of real problems. In that sense, to the second question or the second remark, the 130 legislative acts in the digital domain lack coherence, and that's exactly one of the problems. And I think it's a question also of legislative technique. Is there any consideration about matters which can be taken out of the specific acts of legislation and can be brought to the more general issues? And this is what Florian was mentioning in his introductory remarks, that we do have to think about what can we do with general procedural rules, which allow then for much better learning from problems in one legislative area to another, which allow for standardized procedures, for example, as to what is a hearing. It allows for case law to be developed in one area to more easily be applied in another as to procedural rules, and therefore a much more legal clarity being achieved much faster. And so I am very critical about this approach we are seeing currently in the EU of not just a proliferation of legislative acts, but then to each legislative act, a proliferation of implementing delegated act standards and so on. And in this context, an immense increase of volume of normative acts, and to a degree, this increase of volume leads to a decrease of comparability and of understanding. And so, yes, I think we have to scratch our heads very seriously to see how can we correct this development.
Thank you so much. I'm very much persuaded that there are more questions on the chat, but I'm sure that the distinguished speakers would like to react. But I don't know, Florian, whether we should stay with the questions or maybe immediate reaction. Yeah, of course.
I would like to thank Professor Hoffman. It was very eye-opening for me and insightful the presentation. And as Diego was writing down the keywords, and the keywords you have mentioned it many times, is complexity, proliferation, increase of rules and procedures. And I fully agree with you, and I fully agree also with your observation on experimentalist approach that we have. And now, if I may say, the genie is out of the bottle. We have 130 legislative acts on the area that you were describing, on digital area. And could you please be more specific about how do you see a solution, if you see a solution to that? Thank you.
Well, there's nothing more complex than simplification, as we know. One of the solutions would have been a much better coordination as to, in the initial phase, in the design of the acts. I think in many areas, speed and the perceived urge for speed was at least a factor counteracting the coordination. Another element was with this mass of legislation coming out in the last few years, that the normal legislative process, which is designed for quality control, was simply overwhelmed. Because within the Commission, the drafting took place in ever more technical corners. So, for example, the Data Act and the Data Governance Act was drafted by a different DG with different types of people than the AI Act, and so on and so on. You had, enormous difference. And apparently the legal service and the Secretariat General and the Commission when proposing these acts wasn't capable of chasing these things down. And then in Council and Parliament, I know from advising various people, there was simply no time and no energy to address this. So basically what we have to work on is, I think, in one side, with the Commission as the initiator of legislation to increase the quality there. On the other side, we have this mass now, and there is a lot of movement to reform. So, for example, the GDPR reform is on the table. People are talking about an AI Act reform. The GDPR procedural regulation is somewhere, unfortunately, already fairly far advanced in the trilogue. And many other elements are, being discussed. Then there's the whole debate now about administrative burden reduction, with omnibus in the field of the green transition, but soon also in the digital transition. And basically, we should take those opportunities as a moment to catch breath, step back, and say, which elements can be taken out of these various specific pieces of legislation and can be brought into general, horizontally applicable aspects, and where can we harmonize procedures? I mean, that's why I mentioned the moment of the comitology decision. We were exactly at the time, there were 400 or something comitology committees at the time in the 1980s with highly diverse procedures. Nobody understood what was going on. And the cut was to say, let's take 3 model procedures and roll them out as standard, and from there, step by step, simplifying. Now, this wasn't a painless process. It was actually a quite painful process and a lot of political debate and a lot of institutional conflict, but it was necessary to clarify essentially what is going on. And I think this is exactly an example of what we need to do here, of bringing procedures and structures into certain standards in order to be able to understand better what's going on.
Okay, thank you again for this very inspiring start. And then we move on, we continue with our panel, but we are completely changing the approach, because we are moving from the academic approach to the approach of a practitioner. And rather, you are here to represent the Commission, even if you speak on your personal capacity, that has to be stated. And then you're going to enlighten us about the European Commission's approach in order to ensure effective application and enforcement of EU law. And I'm very much delighted to introduce you all to an old friend of EIPA, Minas Konstantinidis. We are acquainted and friends for years indeed. And then you are legal advisor at the Legal Service of the European Commission. So welcome home again, and then the floor is yours.
Thank you, Diego. It's the French day. I'm a vieux ami, but also an ami vieux. Anyway, so good morning, everybody. I would like to thank EIPA for the invitation. All views are personal, as Diego said, and I would like to talk to you about a topic which is very close to my heart, which is very important to me, ensuring the effective application of EU law. And it is important not because I say so. If we look at the treaties, Article 17 of the Treaty of the European Union, you see that the core tasks of the European Commission, which are first, it is to initiate the appropriate initiatives, to propose legislation. That's the first task. The second task is to execute the budget and manage the programs. The third task is to represent the Union, except the CFSP. And the fourth task is to oversee the application of Union law. It is the task of the guardian of the treaties. And the Commission has gone through various communications to explain how to deal and how to carry out this important task. And there is recently a new approach, as we say, on this issue of implementation by the Commission. But I would like to ask to start by saying that this new approach is not so new. If we look at the history, if we look at the novel of Miguel de Cervantes, if I may, of Don Quixote, we find in the second book, chapter 51, where Don Quixote gives advice to his servant Sancho Panza, when he actually appoints him as a governor of the imaginary island of Barataria. And if I may quote, it's only 4 lines, and he says to Sancho Panza, "Do not make many laws. And if you do make them, make sure they are good, and above all, that they are kept and fulfilled. For laws that are not kept are the same as if they were not existing. Rather, they give the impression that the prince who had the discretion and authority to make them did not have the courage to ensure that they were kept. And laws that frighten and are not executed become like the king of frogs. At first, it frightened them, but in time they despised it and climbed upon it." So in that passage of 16th century, you have the 3 main principles that today the Commission still applies. The principles are better regulation, simplification of legislation, and effective application of law. And if we move fast forward now to September 2024, we will find those principles in the mission letter that the President of the Commission sent to all commissioners designate for the new commission that took office in December 2024. And there the President gives also instructions to the new commissioners, and it is essentially the same. If I may, the very first one, talking to all commissioners, she says, "You should make full use of all instruments for implementation and enforcement, including infringement proceedings." And so on and so on. And if I may, there are many. Well, I have to give it to the President. She's more detailed than Quixote. And a couple of new instructions, if I may say, are that every commissioner has to organize 2 implementation dialogues with stakeholders to align implementation with realities on the ground. This is new. And another new element is that every commissioner in his area, in his portfolio, he should present an annual report, an annual progress report on enforcement and implementation to the respective parliamentary committees and council formations. So the Commission has to be more to have an outreach operation here in the area of explaining how it ensures effective implementation and enforcement of EU law. And the last one I would like to cite from these instructions is that the last point is that the President says to every commissioner that you must contribute to reducing reporting obligations by at least 25%. I refer now, also Professor Hoffman referred to this proliferation of reporting obligations. So here is a clear instruction with a number, reduction at least 25% of the reporting obligations, which is 35% for SMEs. And indeed, I mean, this is really long overdue as a requirement. If I may cite an example of farmers. Farmers, they are supposed to produce good quality and affordable food, but at the same time, farmers have to be IT specialists, environmental law experts. They have to be IT experts. And they have to operate in a free market, and at the same time, they have to be very solidary to our Ukrainian friends. All of that. So it is long overdue that some simplification has to come about in the area of enforcement of EU law. And if I may come to the first instruction of the President, you should make full use, it talks to every commissioner here. You should make full use of all instruments for implementation. So what are these instruments for implementation? Because we mentioned infringements, but infringement is the ultima ratio, it's not the first. There are so many others. And all these are found and described in a communication from 2022 of the Commission, a communication entitled Enforcing EU Law for a Europe that Delivers. And if I may, I will go through I will mention a few of them, which are rather relevant still today, and they were really put forward by the President as a priority for the new Commission. So in the toolbox, we have various categories of instruments, and we could mention instruments that serve to prevent breaches of EU law. outset. And these are, for example, the implementation strategies that the Commission will come up with when new legislation is prepared and enacted. The practical guidance, the Q&A documents that the Commission will produce. There is a proliferation of meetings, if I may say again, proliferation. There are many meetings that the Commission will organize with stakeholders, with member states to explain issues of EU law enforcement and implementation. There is also all tools that have proven to be very, very effective. The Single Market Transparency Directive from 1983. It is a mechanism that requires member states to notify draft technical regulations to the Commission and to the other member states in order to prevent barriers to the single market. And it is a very effective tool because member states, if they do not notify, those technical regulations are not enforceable as recognized by the court. Now, another category of tools and instruments that the Commission will use is actually they are linked with the financial support. It's the stick and the carrot, as we say. The carrot would be that the Commission will finance member states, will give EU funds to member states in order to implement and to achieve the objectives of EU law. Sometimes the Commission even finances the remedying of infringements. On the other hand, the Commission will reduce financing to member states, and I'm referring here to the conditionality regulation, which is an instrument that protects EU budget from member states that violate the rule of law. And the other category is an early detection and the resolution of breaches of EU law before we arrive to infringement proceedings, I mean. It is transparency instruments like the scoreboards that the Commission will publish of member states. It's a name and shame operation. The member states that violate EU law, there will be some bad publicity there. And also in the area of EU budget management and sound financial management of member states, the Commission will not use so much the infringement proceedings. It will use audits. It will use audits in the area of the cohesion funds, agricultural funds, and the result of these audits, if irregularities are revealed, the Commission will take decisions of financial corrections. It will, and those decisions can be then challenged by the member states at the court. And it is important in that regard to say that whereas in infringement proceedings, the Commission has the full burden of proof, in this area of audits and financial correction decisions, the Commission has only to establish a reasonable doubt about irregularities in the management of the EU budget. And then it is up to the member states. There is a shift of the burden of proof to the member states to prove that the control mechanism and the management of EU budget, EU funds was appropriate. There is also the instrument of EU pilot, which came back as a pre-infringement tool, where the Commission will use it in order to clarify the facts of a complaint, of a case of violation of EU law. And at the end, the last but not least tool that the Commission has is infringement proceedings. Since 2016, there is a new policy, if we can say, of selectivity, or better say, of strategic approach of the Commission as regards infringements, in the sense that cases of individual in violations of EU law are not pursued anymore by the Commission, but they are left to the national stage. And the Commission will only take up cases of systemic violations or of non-transposition of EU law into national law. And with this, I will arrive to my concluding remark, that to say that, well, if we have to cite any keywords here about the policy of the Commission, the new approach on implementation, it will be now, it will come from the Commission's work program of 2025, where we talk about bolder, simpler, and faster union, which is the only appropriate response. We are in an area and in an era of many crises, one after the other. The Commission will have to deal with it as well. And I would like to put to all participants a last question, because we operate under the treaties, and the treaties are actually, the treaty we have is the treaty of, the last amendment was the Treaty of Lisbon in 2009. We are 2025. If we go back from the Treaty of Lisbon in 2009, we had Nice 2003, we had Amsterdam 99, we had Maastricht 93, we had the Single European Act 87. Every 6 or 7 years, we had modifications. Since 2009, we are living with the same treaty. Is that a problem for you? And is it a problem that, is it fit for purpose, the Treaty of Lisbon? And is it a problem that we cannot even imagine, in my humble view, a modification of the treaty because of practical and known reasons? Is it a problem that we have a union with the treaty frozen, actually? Or if you don't agree with that, please go ahead. Or maybe it's not a problem at all. Thank you very much.
Thank you very much. Thank you. Again, a very useful presentation. You have referred to the panoply of instruments, to the toolkit that the European Union has to, in order to enforce EU law. Again, any single of the instruments that you have mentioned would be worth a particular explanation. And we are going to follow the same dynamics. We are going to open the floor for immediate questions, reactions, and evidently we'll have the time for a plenary debate at the end of the panel. But then I look at my colleague Beatrice, who's running the chat pad. I saw that there were some comments being dropped in the chat pad whilst Minas was speaking. Maybe you can guide us to those comments.
Yes. So we have Jack, who asked Minas actually, what about coordination between the Commission services and possibly codification of existing instruments in order to eliminate incoherence? He adds, these were the issues put on the table by Prof. Hoffman.
Yes, I think codification is a very powerful tool, and I think Professor Hoffman alluded to that. And not only to have, we are coming back to Professor Hoffman's, I think, topic here, which is very interesting. Not only to have an act on administrative procedures, a general act, which, as you know, the Commission likes very much, but to have a codification of existing procedures. And but as Professor Hoffman said, it is a very complex and difficult issue to simplify. But I have to tell you that in the legal service, we have a unit, actually there are only 3 colleagues who deal with codification, and there is an effort to provide in various areas legislation that it is codified. And I think it is a very useful tool. I fully agree with the person.
Thank you. Any other question which is on the chat? Otherwise,
we have one other question very quickly, so then because we're running out of time. Someone else asked, the Commission's 2025 work program emphasizes simplifying legislation and reducing administrative burdens. How does the Commission balance these objectives with the need to maintain comprehensive enforcement mechanism to ensure member states' compliance with the EU law?
This is a very good question. Thank you very much for the question, because there is a bit of a paradox here, because the Commission is asked to provide for simplification and to alleviate the burden of all stakeholders, of member state administration, of SMEs, of businesses. But nobody thinks about how the Commission can do that. Actually, the Commission is constantly asked to do more with the same or less resources. And if we think that, as I said before, that one of the core tasks is to oversee the application of EU law, it is a bit illusory to expect the Commission to carry out all these tasks and at the same time to be everywhere, to have a watchful eye everywhere, and to respond effectively to the violations of EU law. And I have to recognize that also the response is a bit uneven. You have DGs who are very professional and they carry out infringement proceedings in a very diligent way, and you have other DGs, you talk about infringements. Oh, no, we are policy DG, we don't do infringements. Yeah.
Okay. Thank you so much. I think it's time to move on, unless there's an immediate reaction. And then if we speak about current developments, we have to certainly mention the AI Act. And then it is for me a great pleasure to introduce you all Dr. Melanie Fink, who's assistant professor at the Leiden University. And she's going to refer to us precisely to the AI Act as a trigger, for EU power, for extension of the regulated powers of the European Union. So again, you're going to be speaking about this administrative law in context, in a particular policy context. So welcome, and the floor is yours.
Thank you so much. Thanks a lot for the invitation. I'm really happy to be here. And the previous two speakers have set the stage wonderfully for me, so I can keep my intervention pretty short. As you said, I will talk about the impact of the AI Act from a broader perspective. And the point I will make is actually that, as we know, the uptake of AI in public administration increases along all domains, basically. But as this occurs, we can also expect to see a commensurate expansion of EU public power. And what that also means is that as the relevance of EU public law increases, the legal authority of national public law decreases. And in the following 5 minutes, I will explain just a little bit why and how I see this phenomenon happening, and then more importantly, what lessons we should draw from it. And you'll be happy to hear that there is also some opportunity I see there for the solution that Mr. Konstantinidis was asking Professor Hoffmann about. So I hope we can discuss that a little in the plenary discussion. So the background to it is a little bit that, as we know, when a provision of secondary EU law applies, it brings with it what Advocate General Leynard once called a shadow, and that shadow is the general principles of EU law and the Charter that also apply. And so what does this mean for the AI Act, or in the context of the AI Act? Now, the AI Act as a piece of secondary legislation contains a lot of, it goes a bit into the direction of what Herwig was saying, of procedural rules to ensure accuracy, fairness, legality of outputs, but it doesn't really contain substantive rules for that output. So what does that mean in practice? If we take the example of what ended up being the Duo scandal in the Netherlands, if we imagine a public authority that uses AI-created risk profiles of individuals to assess their likelihood to commit student loan fraud, and then on the basis of that risk assessment, maybe decides whether or not to do house searches, home inspections, and on that basis maybe demands repayment of the student loan. Now that decision is of course governed by national law. There is no EU competence in this area, but the procedure to reach it, to the extent that that this AI system is used, is governed by the AI Act. So in the sense that this authority will have to do a fundamental rights impact assessment, will have to ensure that human oversight is guaranteed throughout the operation of this AI system, and also, that explanations are provided for whatever decision is taken. Now, what's obvious is that the more AI is used in these procedures, the bigger the impact of EU law. Why? Because the AI Act applies. But in addition, of course, with it, comes this shadow of EU public law that then also applies, and is monitored by EU procedures, including, of course, the Court of Justice of the EU that will review this instead of the national courts in this respect, in any case. Now, the fundamental point then is that the AI Act as such represents not just the regulation of the technology, but also kind of maybe more subtly, but a shift or a transformation of this boundary between EU public law and national public law. Now, what do we make of that? There is several layers to it, or several perspectives from which you can look at this phenomenon. One is, of course, the EU level. And from how I see it, we could look at this as an opportunity, and this is where we could also maybe find a solution. Professor Hoffmann was before referring to also the lack of consistency, or the difficulty in any case to ensure consistency between all these 130 pieces and more coming of secondary legislation in this area. Now, if EU public law and especially EU administrative law becomes more relevant, it of course also means that we could use that to concretize and especially ensure consistency among this secondary legislation through, who knows, maybe codification of principles like good administration in this context. Of course, there is also, this also has an implication for the monitoring mechanisms that were referred to before, that are diverse and complex and atypical, and each of them has their own procedures. It also means that they, to some degree, have to anticipate this effect by looking into how EU administrative law could govern these bigger questions. Well, this is very general now, but maybe there is room in the discussion to dive deeper here. I just want to also mention the national level perspective here, because of course this also means, if you look at this phenomenon more broadly, that there is a much bigger impact on national procedural autonomy that may be immediately obvious from looking just, let's say, at the AI Act itself. So that is something to deal with. And then my last point, even more broadly, this really, it's almost like the hybridity on steroids, if you may say. Maybe you will come to hybridity in your intervention, so I'll not say much more on this. But of course, what this means is that we have these multi-stage procedures where different laws and different whole frameworks of public laws apply at different stages. It might not always be that easy actually to distinguish then the procedural, where the EU law is more dominant, from the substantive, where in this example I mentioned before, national law is more dominant. So in theory might be neat, but in practice not so much. And this is of course something that's really difficult to navigate in terms of monitoring, but also actually the protection of individuals affected by this decision. And I leave it at that and hand over the floor back to you, Diego. Thank you.
Fascinating presentation, Dr. Fink. I would retain, this perspective of, the domestic public power, the European public power. You could say the lines are being blurred. What I retain from your presentation is that rather there's an interference of European public power in the domestic realm, rather than a blurring or a composite procedure, or getting out to a situation of a hybrid nature. This is what I would retain: progressive interference or expansion. This being said from my side, then we follow the same methodology, and then I turn my attention to the chat pad, to the speakers, or to to the participants following us online. And I know that some of you work directly on the field of artificial intelligence, so maybe there are questions from those particular participants. Otherwise, I would turn immediately the floor to our distinguished panelists, panel one, or maybe you cannot see them, but they are sitting next to us, the panelists of panel two, they are opposite me. Evidently, you can also intervene if you find it pertinent. Any question to Dr. Fink? So there will be certainly questions then probably at the end of the session when we'll be coming up with coming up to the wrap up. Now Florian, you have a question, it seems, yes, right? Okay, so therefore I was to.
There is nothing from the online environment. Maybe very quick throwing a question, because indeed that's very fascinating how adopting EU legal standards sometimes, basically that's, I think, your main argument, blurs in a way the delineation and the weight in a way in the relationship between EU administrative law and national administrative law. And my question would be, is this something really, or is there anything specific about the AI regulation, the AI Act in particular, as compared to other EU regulations like the GDPR, for instance? Do we see different developments, qua process, when EU adopts a new regulation in a specific field, and how this interacts basically with the national, let's say, legal order, and in particular EU administrative law? And the second, perhaps point very quickly maybe to address is, and I think we discussed this even before this, is how do you see basically the impact of this Europeanization of EU administrative law on the principle of national procedural autonomy from this perspective? Maybe with reference to the AI Act, if you want.
Yeah, thanks so much. Yeah, I do see the specificity of AI regulation in this context in the way that AI systems are integrated into administrative procedures, which makes it, these are all multi-steps procedures, of course, and the AI system is used in one, but it's really difficult to pull this apart so that the impact, as I see it, really sort of seeps into national administrative law to a greater extent than maybe other instruments might. And this is all the more so if we anticipate that AI systems are used more and more and more and more. So that's also the bridge actually to the next question. Yeah, I do think that the impact on national procedural autonomy is deeper here than, for instance, also what we see in the GDPR. Just maybe one example, if we think of the requirement in the AI Act to ensure human oversight. Now, yeah, this could be a whole panel, of course, in itself, but what we see is that this really affects the structure of the procedure in question. And that this Europeanization just is deeper. I'm not sure this makes sense to you, but so that's where I see this distinction. But be really curious to hear more thoughts on the role of national procedural autonomy in this context. Yeah.
So then it's time to move on, and then I give the word back to Florian, who started in fact the event. And I would reiterate that Florian is our senior expert in EU governance here at the European Institute of Public Administration. And Florian is going to enlighten us about legal protection against EU administrative action, and then he's going to come up again with this keyword, which has already been mentioned a number of times: synergy between non-judicial and judicial remedies. Please.
Thank you so much, Diego. Well, let's say I'll try to keep it short. Let's say my statement basically has indeed consists of two main points. And let's say these have been more or less, well, let's say the focus of my latest research work as well. So I'm also very curious to to share, also to hear reactions to these statements. So maybe in a way I'm going to make them a bit more challenging to trigger some reactions and see how this is going to work. So indeed, the first statement is about basically the legal protection or how to ensure, let's say, better legal protection against EU administrative action. And this starts actually from the observations that let's say when looking, I mean, we see a lot of developments in terms of, let's say, increasing powers of EU bodies, agencies, etc. So basically conferring more and more, let's say, if you want, sometimes direct administration or direct enforcement powers to various EU bodies, agencies, institutions. But what seems to be largely missing sometimes in this whole picture is indeed the idea of, the legal protection of the individual, especially when such EU action, let's say, can actually, directly affect or even indirectly affect the fundamental rights of the individual. So basically, my idea is in a way to question this idea of a complete system of, if you want, judicial legal remedies, but broader than that, the idea of a complete system of legal protection for the individual against EU administrative action. And basically, let's say, I said, let's say when it comes to examples, let's say one example pertains sometimes to direct factual contact by the EU administration, for instance. I mean, starting with data processing operations and the way in which personal data is being used, for instance, in a way that can actually affect the individual, as I said, directly or indirectly. Going to more, let's say, concrete aspects, for instance, when we have direct law enforcement actions by, let's say, Frontex staff during a joint operation or during a return operation, or thinking about, even more complex, if we want, this kind of very, new development, we would say, when we have the European Public Prosecutor's Office, for instance, carrying out criminal investigations and prosecutions against individuals who might have committed crimes against EU's financial interest. So basically, of course, we have legal protection and judicial remedies in all these cases, but my point is that, these actually are not, let's say, do not fully cover, let's say, the harm that can be caused to the individual's rights. And therefore, let's say, my main idea or my main point here, suggestion is that basically a complete system of legal protection for the individual against EU administrative action entails more extensive reliance by EU courts and the EU legislator on the principle of good administration and the principle or in combination with the principle of effective legal protection, both reflected as general principles of EU law, so basically developed by the Court of Justice, but also reflected as fundamental rights in Articles 41 and 47 of the Charter. So based on this, some concrete recommendations or suggestions are that the EU courts actually should reconsider their restrictive approach on the access and redress for the individual under judicial review remedies provided in the treaties. In particular, when it comes to Articles 263, 265, also Article 340, so basically EU damages for, or EU liability for damages caused to the individual, and that basically this, let's say, reconciliation should be done by reading, in a way, in a fundamental rights friendly fashion, these remedies, and in particular in light of Article 47 CFR. And also, I think that courts could contribute indeed, because it seems, and I saw from the other interventions, we have indeed serious problems in terms of, right to good administration. I think in panel 2 we'll have more focus on that. And here as well, let's say I have I would suggest, or it is suggested that the courts could more actively contribute to the understanding of good administration, be it as a general principle of law or as a fundamental right enshrined in Article 41, as including also an inherent obligation for the EU administration to establish fully effective non-judicial remedies for the individuals invoking breaches of their fundamental rights. And also, I think the EU legislators should actively develop, and I think we miss this quite a lot, a coherent and effective system of non-judicial remedies with the idea of fundamental rights or legal protection of the individual in mind. I think we sometimes see all these legislative developments really focusing on very pragmatic issues regarding, enforcement, implementation, regulatory standards. But I think when it comes to the idea of, well, so what do we do when things go wrong? And what do we do when, let's say, the action of EU of the EU institutions, let's say, affects individuals, then what remedies do we offer? I think this is largely missing, and the EU legislature perhaps should take a closer look at this aspect to further address it. So basically, my point is that on this one is looking forward is that, well, basically two observations. I think that also we as lawyers, we have the tendency to focus a lot on judicial remedies. But I think normally for the individual, this is not the most relevant thing. The most relevant thing for the individual is actually to obtain, sufficient redress for the breach of his or her rights via administrative action. So what, from the individual's perspective, would be more useful, I think, is to have easily accessible non-judicial remedies offered by the EU administration in the first place, before actually going to court. And only to the effect that such remedies do not work, then basically the point would be that, well, you have the last resort option, which is judicial review. So that should come really at the end. So that's why I think it's important to focus more on developing principles, safeguards, and criteria for building such effective administrative remedies for the individual. So basically, also, and here is also interesting because we have administrative, not remedies, but review mechanisms. But the question is to what extent administrative review mechanism always represents also a remedy for the individual. And sometimes we have interesting procedures, like complaint procedures, for instance. Frontex could be a case in this respect, where basically, well, we see that the individual can trigger that, but it's not necessarily that the individual would benefit from that. So again, I think we need a kind of serious kind of reflection on how basically review mechanisms could also be coupled or linked to the idea of effective administrative remedies for the individual when he or she suffers breaches of his or her fundamental rights. And then, the idea would be also second point, so that the combined reading of the principle of good administration and of the principle of effective judicial review could support, let's say, a more complete system of legal protection against EU action, featuring easily accessible, comprehensive, effective, non-judicial remedies with, in principle, judicially reviewable outcomes. So basically, the idea would be that, well, as a rule, not always perhaps, if we have good reasons for that, non-judicial remedies that could be offered to the individual should result in a finally legally binding act that can be challenged before EU courts by the individual, so that in this way the individual could first have the opportunity to obtain appropriate redress, let's say, the quicker and easier way, so via the non-judicial remedy, with the safeguard that his or her rights will be ultimately be protected by EU courts if the relevant EU institution or body fails to do so. And then very quickly, the last point, and this is going to be short. The last point is indeed about, linked a bit to this, but still a different kind of focus, the idea of hybrid EU administration and what kind of legal review challenges this might create. So basically, let's say that, we started using this term of hybrid administration as well, analytically, basically describing situations in which, they were discussed before also by Professor Hoffman and by Minas Konstantinidis here, and also by Melanie. They will be discussed further on in panel 2, but basically, let's say, describing situations in which tasks and powers of EU and national actors are entangled under complex multi-level legal frameworks and operational environments. So I think, in a way, we have different types of forms of manifestations of hybridity in this respect. So one could be procedural, one could be substantive, one could be more organic sometimes, networking, where we have basically, various actors embedded in, hard to decipher operational networks. And again, we see this kind of development in the last years more and more often, and perhaps, I think they are symptomatic of the current level of the EU administrative integration degree, I would say, And maybe they could well contribute to the effectiveness of the EU law and policy implementation. However, they also raise some important questions, and I think here accountability and legal review is a core question, because it becomes increasingly difficult to review, let's say, the action of such actors when they operate under tightly integrated multi-level frameworks and share increasingly hard to decipher ways executive and operational tasks and powers. So sometimes we don't know who does what exactly, who, and basically to whom actually the ultimate act can be attributed, and then how to hold each particular actor accountable in this respect, and also how to ensure sufficient redress to the individual. I mean, against whom should the individual go, and which court then? And this basically brings me to the final remark. Actually, one consequence of this phenomenon, I'd say, is that let's say EU-level actors in this respect more and more often become subject to a mix of both EU and national legislation. So basically, the point is that you have increasingly EU institutions, bodies, agencies applying or complying with both EU law and national law because of this kind of hybrid intertwined, let's say, administrative frameworks. And of course, this, let's say, creates at least, I would say, it creates serious problems in terms of legal protection and I would say judicial review more generally, because let's say we still have currently systems, well, let's say the judicial review system still largely operates based on the principle of double exclusivity, according to which basically EU courts will deal with the actions of, or only EU courts can deal with actions of EU actors, whereas national courts deal with the matters of interpretation and application of national law. Now we have certain kind of, let's say, if you want, piecemeal approaches taken by the Court of Justice in certain policy areas, such as a single supervisory mechanism, where the court took in a way the initiative to interpret national legislation or to rely on the national legislation of national courts, but I would say most significantly, even interpreting such national legislation when the national courts didn't do that, to basically review actions of the European Central Bank applying national law, but not sure to what extent, I mean, of course, not sure to what extent such solutions could be, extended, let's say, to the whole landscape of hybrid administrative structures across the EU policy areas. And one last point is that we have also maybe a second kind of model, and that is the case of the EPPO, which it's again in itself controversial, I would say, also in terms of compliance with the treaties, but that's another discussion. But nevertheless, based on the EPPO regulation, we have this new model where basically national courts deal with the procedural acts of the European Public Prosecutor's Office. So basically, mainly the delegated prosecutors, but sometimes also acts adopted at the central level. So this, in a way, has been seen as a solution, or as a, let's say, perhaps an imperfect solution, but basically a way forward to basically have the EPPO regulation adopted ultimately. But I don't know to what extent, such a solution could be further, well, explored to, well, let's say, apply maybe in other kind of hybrid administrative structures, environments, or let's say frameworks, in the absence of actually treaty amendment regarding basically EU judicial review mechanisms and remedies. Thank you.
Thank you so much, Florin. Indeed, another very interesting presentation, a good way to conclude our panel. And I would retain from your intervention that whereas these composite procedures indeed facilitate decision-making, they trigger a plethora of problems as far as legal and administrative redress. You have mentioned some of them. Problems of attributability, problems of accountability. There's an element as well of the law applicable in order to seek redress. So thank you for enunciating different solutions to that particular problem. So I'm looking at the clock, which is standing to my right, and I see that we still have 5 minutes, and I see that there are questions to Florin's presentation. Is that right? Not? No. So I'm looking at my colleague, which is running the chat pad. So any question from the panelists, maybe to Florin's intervention? Too many questions. That's a good thing. I mean, we need now to try to fit those questions in the remaining time that we have. So it's going to be quite a challenge, but please, Venus.
Thank you very much. First, a question of if I understood well, you were talking about introducing administrative review mechanisms as non-judicial remedies in case of an act of the union adversely affecting the interests of a person in general, non-judicial remedies, and not to invoke the principles of good administration and effective judicial protection in order to bend Article 263, 265 standing requirements. So it will be like, if understood well, like the Arcus regulation, for example, where you have an administrative decision on the review, and that decision is the one that the individual can challenge at the court, and not the original decision on environmental matters of the union, no? Something like that.
So let's see. Yeah, that could be one of these kind of possibilities, and of course, as I said, that would be in the idea of having this kind of administration respecting the principle of good administration, and also good administration is a fundamental right. I would say, well, this should include an obligation for the administration to first provide possibilities, actual possibilities for redress to the individual, before actually the individual is forced to go to court. So that would be indeed the idea, the system of, if you want, more internal administrative remedies, or let's say it could be internal or external, but definitely non-judicial, because I think in terms of, offering quick redress to the individual, that would be the best way, the most efficient way, the most effective way, also because the judicial review of the court sometimes is limited to various aspects. We know not only about the admissibility requirements, but also about the limits of substantive review. So basically, and of course, one perhaps impediment for judicial procedures is that they are costly and they are very time consuming. So it takes years up to the point to basically manage to, well, let's say, get some redress if it's not too late already. So that's why my suggestion would be, well, the administrative should jump in first, try to, well, if it acts in good faith, it should be able, I think, in most cases, to remedy the situation. And only if this doesn't work for different reasons, then the individual should have still the access to court. But maybe also, just to be sure here, one thing is also to think about the procedural aspects maybe, and the entitlement of the individual basically to also, that's I think open to discussion. Should the individual have a duty to go first to the administrative mechanism before going to court? Or should the individual have a choice before, well, if I want, I'm going to use the administrative mechanism, but if I also want, if I don't trust it for whatever reason, I can also directly to court against that decision.
May I just come in here, if I may? Because there is another trend in many policy areas in EU administrative law to push out the individual. So the way composite procedures are introduced and structured means there's a focus on the interaction between the European and the national administrative level, but individuals are less and less treated as parties to a procedure, but more and more simply as informants. And that's an attempt to make this system work, but it has extremely detrimental effects on the quality of decision-making, on hearing, on possibilities of integration of information into decision-making. So that's, I think, a trend which started as early as the state aid procedural regulation of 1999, where complainants were simply excluded from the procedure. But unfortunately, that one can observe in more and more policy fields. And that, I think, is also not just bad for the quality of the procedure, but also bad for the image of the European Union and the understanding of the Union being a body of law which includes individuals, which is its strength always. And the other element, I think, which is really important, which goes back to Melanie's discussion, which is one of the weaknesses of our legislation in the moment and the approach to legislation is to try to be ultra specific on technology and to address always the latest things. So whether we're talking about, just imagine and remember when we were talking about the AI Act, suddenly generative AI came into the game and was developed. And suddenly everyone woke up and, oh, okay, we have to change the AI Act in order to make it adaptable. Or the same with recommender algorithms in the context of the DSA. Technologies which are permanently changing. One of the problems in the legislation is not just the complexification of procedures, but also a lack of awareness of technology-neutral approaches of exactly developing structures which allow to adapt to fast-changing realities. And this awareness also in legislation, I think, has gone missing a little bit in the last waves of legislation and should be brought back in.
Thank you, Gavik. I'm aware that our time is up, but since both names were referred, Melanie, Florin, maybe you want to quickly react before we close?
I have just a very brief comment. It's not even what I wanted to ask Florin. It's now more a reaction to what Herwig was also saying. I think there is, there is so much to be said about it, but what plays a big role, maybe why this trend happens, is also that expertise is really sort of siloed. And Lisette and I were talking about this before. There is a lot of competence on, for instance, law and technology, but that does not always include EU law, much less EU public law. So yeah, it results in these ultra-specific provisions that are also then interpreted in isolation of everything else, without still something like the good right to good administration or something like that actually filtering in. I close here without a question now.
Very quickly, thank you, Herwig, for these comments. Much appreciated. And maybe just one quick remark on the idea of making complainants part of the procedure. So basically, involving them in the procedures with procedural rights, basically. So enabling them in this way to, defend their interest and position, or make their view at least known in the procedures. I think there is indeed a trend that, seems to be also confirmed to some extent in jurisprudence. Maybe Lisette will say more about this in panel 2. I think we have this SUFA judgment, basically, where actually the court confirmed that, let's say the complaint procedure to the data protection supervisory authorities actually also represent a review or, let's say, redress mechanism for the individual. So I think this trend seems to also, let's say, get some sort of echo in the jurisprudence of the court. Definitely, I think there should be more kind of systematic and coherent approach on this. I mean, not only encompassing specific policy areas, but rather, I would say, rather broader kind of principles and standards in this respect that then could be perhaps applied in a tailored fashion depending on the policy area or regulatory framework involved. That's basically it. Thank you.
Welcome back. So we are back as we promised this morning, and then we are going to tackle the second bit of our open day on EU administrative law. This morning we spoke about the current status quo. Now we're going to change slightly the dimension, and we'll be following now the same methodology. I will, very well flagged by 4 distinguished panelists. But now we're going to be speaking about the challenges. That is, it will be mostly having a forecast look of what's going to come ahead. So, as I said, we're going to follow the same methodology, and I would like to invite immediately, it's the first time to get acquainted, welcome to APA, to Professor Mariolina Eliantonio, who's Professor of European and Comparative Administrative Law and Procedure at the University of Maastricht. And then she's going to be dwelling upon a couple of words which we have already mentioned this morning, which is this hybrid or composite procedures, and how these composite procedures have an impact on matters such as legal redress, judicial review, etc. So we are very eager to listen to you. The floor is yours. So welcome.
Thank you very much. Thank you very much, Diego, and also thank you, Florin, for inviting me, and also happy to be in this very nice company of academic friends interested in composite procedures, administrative cooperation, and more broadly. I think the first part of my intervention this afternoon will be perhaps a bit of a summing up of plenty of threads that have emerged in the course of the morning. First of all, to go back to the definition of composite procedures, the first thing that I do want to mention is that composite procedures, which have been evoked in the morning a couple of times, they are not a dogmatic category in the mind of the EU legislator. They are a product of our academic reflection. In a way, big news for those nerds like me working with this topic is that the Court of Justice has actually used the terminology composite procedures in case law just a few months ago. But up until now, this was, as I said, more of an academic creation. And in practice, these mechanisms of cooperation between national authorities themselves and between European and national authorities have emerged more or less organically in the way European policies have been structured. But it is quite clear, and I think the example of digital regulation, which was discussed this morning, show they have emerged without a coherent path ahead, without a coherent plan, and without a coherent umbrella structure. What has happened since the inception of the process of European integration, really, is that a number of measures of EU secondary law foresee various types of cooperative patterns between EU authorities and national authorities, so vertically, but also between national authorities themselves, so horizontally. The universe, let's say, of composite procedures is very difficult to encompass because it is so diverse. So you can have procedures, as I said, which are vertical in nature, so they involve national and European authorities. This can be in various types of policy areas. For example, one that where there has been also case law on the side of the Court of Justice is the one of funding. But you have also procedures that are horizontal in nature, involving only national authorities for the implementation of EU law. And Professor Hoffman this morning was talking about tax. For example, tax cooperation is a typical example of cooperation that is purely horizontal. They may be also, if you look at vertical procedures, the cooperation of national and EU authorities can take place at different moments. So the procedure can start with a national action and finish with a European action, but it can be also the other way around. It can start with the EU action and the procedure can be concluded at the national level. So you have all sorts of possible constellations and combinations. Sometimes these procedures involve the role of comitologies committee at the level of the EU. Sometimes they don't. Sometimes they involve also European agencies, which are supposed to provide advice very often, for example, in the case of food safety, in the case of medicines, but they also are involved for more enforcement purposes, in inspection purposes, but also just to carry out purely factual actions, as Florin was also mentioning in the morning in the context of Frontex. Also, when you look at the way in which these procedures, so what kind of actions are being adopted in the context of these procedures, it can range from a binding act, a regulation, a report, an opinion, but also, as Herwig was mentioning this morning, a piece of information that is shared, but also simply a factual act of seizing a computer in the field, for example, of banking supervision, or also simply the fact of stopping a migrant. That is also part of composite procedures. And where matters become more complex is when these procedures entail an integration that goes in such a granular way that eventually it is next to impossible to find out, in very simple terms, who did what. in the course of the procedure. Florin mentioned this morning the question of, or the issue of Frontex cooperating with national authorities in the pushbacks, but even imagine in the field of financial regulation, national authorities and the authorities from the ECB cooperating in an inspection. Well, one might be opening the door, the other might be seizing a computer, the other one might ask a question to a witness, the other one might be writing a report. So who is doing what, really? And according to which procedural standards, fundamental rights, should they be, these national EU authorities be accountable to? And that is the second part of my intervention, which is the question of judicial protection. So in this remainder of my intervention, I will focus on the judicial side of protection, and the speakers after me, will continue certainly discussing non-judicial avenues. Now, the problem with these mechanisms of cooperation, which are virtually existent in all fields of EU law, is that the system of decision-making has become increasingly more intertwined, entangled, integrated, but the system of judicial protection has remained very separated. And I think Florin was mentioning this this morning already, whereby the starting point, let's say, is that the judicial instances are only competent to review acts of belonging to their own legal systems. Now, this can generate gaps of judicial protection, which the Court of Justice went to partially repair in the course of the year. The situation is such today that basically for the procedures which involve the operation of national and EU authorities, so the so-called vertical procedures, the distinguishing criterion as to whether separate judicial review is applicable, so each court competent for their own matters, so to speak, or centralized judicial review in the hands of the Court of Justice, the determinant criterion is that of who of these authorities is actually in the driving seat. If the actual, if you wish, de facto, the real decision-making is carried out by the national authorities, then judicial review is separate and each court is competent for their own part of the procedure. If instead it's the EU authorities that are in the driving seat of the decision-making process, judicial review is centralized on the side of the Court of Justice. Now, this seems to solve quite a few problems, but still opens up a lot of further questions. For example, in the case of separated judicial review, let's imagine the national court said, well, this national part of the decision-making process was unlawful. Well, that of course reverberates on the legality of the EU Act. But what is there to happen concretely once there is a national court ruling saying this part of the national process or this national decision was unlawful? Well, how should even the Commission get to know that this proceeding was going on? In a later case law, the Court of Justice said, well, there is a duty for the Commission to withdraw or revoke. I don't know what would be in European administrative law terms. There is not such a well-developed terminology for this kind of acts of the EU authorities to withdraw from the legal universe their own decisions. The Commission is supposed to do something for this act, which has now become unlawful. Okay, what if the Commission, how does the Commission get to know? What if the Commission doesn't do it? Is there an action for failure to act that opens then? Not clear. In parallel, if it's the Court of Justice that is competent for the entirety of the process, then what happens if what is wrong is the national part of the process, but not so much for the violation of EU law, but for the violation of national law? So the Court of Justice becomes competent, in fact, for reviewing mistakes of procedure under national procedural law. So is this even possible? So these things are still very much open. If we look now just very briefly at horizontal procedures instead, there we have yet another situation because we have kind of sovereign equality between member states. So should a court of a member state be entitled to review the lawfulness of an act that comes from a different legal system? Well, the Court of Justice, in the line of case law that concerns cooperation in tax matters, said yes. The right to effective remedy enshrined in the Charter requires that national courts should be able to review foreign parts of the process, so preparatory acts stemming from a different legal system, against parameters of EU law. But then in another case that concerns the visa legislation, the Court of Justice hinted at the fact that these foreign measures need to be litigated in the courts to which they belong. So is this now separated? Is it centralized, or one, not centralized, but so much one single judicial review avenue? It is not clear there if the determining criterion is, again, the one of discretion, or if there is something else. So finally, a very big problem, I think this was also mentioned by Florin this morning, when factual conduct is at stake, there is this very fundamental problem of attribution. So in these cases which I have mentioned, there was no problem to identify which act belonged to which jurisdiction. In the case of cooperation, for example, in pushback of Frontex or in inspection tasks, it becomes increasingly difficult simply to know who did what. And then, of course, also which court is competent for what. So I come to my conclusion. Composite procedures are prevalent in virtually every field of EU law. At the same time, they have a bit mushroomed here and there in the different policy fields, and they are not a category, a dogmatic category in the mind of the EU legislator. Because of this erratic development of these regulatory structures, the Court of Justice was seized on a number of occasions to intervene to fill these gaps of judicial protection. They have achieved that to some extent, although certain questions still remain open. At the same time, my final point would be there is only this much that we can ask to the Court of Justice to do and to achieve in terms of filling these gaps. And I think that the way the judicial redress mechanisms in this increasingly integrated administration should come to the agenda of the legislator and not just before the court.
Thank you so much. Thank you so much. Indeed, an excellent presentation, and it has been an excellent bridge between the contents of this morning, like the conclusive presentation of Florin, and then the start of the contents of this second panel. Again, you have insisted upon this dimension, composite procedures, how useful or how effective they are for decision making, but the problems they trigger as far as judicial control. It has not only been interesting, but I would say as well, enormously thought-provocative, at least in my respect. But you know, in my duty of chair, I have to retain myself. I cannot ask questions. I should privilege the audience or the panelists. So therefore, we open the floor for questions, either from the audience or from the panelists of this afternoon or this morning. Please. Please, Melanie, you have a question?
Thank you so much, Mariolina. Really like this overview. I just wanted to zoom in for a moment on this attribution of conduct and maybe more to add maybe yet another thought or yet another complication, which is that interestingly enough, EU law provides no rules, no general rules for attribution of conduct, which I think, especially when you compare it to public international law, where this exists, is quite an interesting observation, and also an area where I fully agree with Mariolina, where I think there is a lot of room for the legislator to step in and provide this type of clarity more broadly also.
Want to react to?
Well, apart from agreeing, what I would say in addition to that is that would not even require this mythical horizontal codification of composite procedure or of administrative procedural law. So even if we don't want to dream of that, still in the specific piece of legislation, some provision could be made on a sectorial level on how to solve this situation. So it's much more also low-flying in that sense than a very ambitious horizontal kind of codification.
Please,
Can I offer an example? Exactly, I fully agree, and this is for the co-legislator. That was also would be my observation. It is for the legislator to solve this issue sector by sector. One example which I may offer as a good example is the regulation of the quality schemes on foodstuffs, or the protected geographical indications, where you have the technical specific. It's a composite procedure, a vertical one. First, the national authorities, they come up with a specification, the technical specification of the product, national procedure, and then it is for the Commission with an implementing regulation to register the name. And the regulation provides that if there is a national judicial procedure whereby you have the annulment of a specification, the member state has to notify that to the Commission, and the Commission has to take the consequences from that and to withdraw the name.
I would say this is definitely a best practice. I wonder, well, does it come perhaps in your view from the fact that this is a long-standing piece of legislation with which there has been a lot of experience, that kind of a lot of problems that have emerged in practice have been later codified?
You're absolutely right, because at the very first version there was no indication on this conflict, and with case law, the legislator, the Commission proposed, and the legislator took it up, and now it is.
May I also ask something in addition? What we have also seen is that this tends to work best in areas where individual rights are not really fundamentally affected, like now the comparison with Frontex, where rights that are really close to human dignity tend to be affected when things go wrong. And what we have seen is that there, even if you define beforehand who is responsible, accountable, what for, when it comes to these types of violations, individuals tend to, for justice in a subjective way, tend to how do I say it? It would be difficult to say, oh, it's the national authorities that bear responsibility, even if that is decided beforehand, because when the individual sees the Frontex badge and they feel that justice is only served when that that party is also held accountable. So I wonder whether that would somehow, I suppose, have to be featured in this
I agree
design.
with you, although even in the example that I mentioned, we still have court cases. We have a pending court case where the producers of halloumi cheese in Cyprus that the Commission should check whether this cheese should be from a goat cheese or a cow cheese, whether the Commission says, well, it is for the national authorities, it's not for us, there is no standing.
So
and
even
it is
there,
pending. This case is pending.
Okay.
I see that Professor Hoffman has raised his hand, his virtual hand, so I suppose that you want to intervene. Please, Herwig.
You are mute.
You're on mute.
Yes, I'm afraid we cannot
Another
hear you.
aspect to this
Yes.
appears more and more in practice, and Lisette and I were recently working on the GDPR procedural regulation and advising in that context, and the problems there show very strongly that an issue is not only of who is responsible for which part of which procedure, but also who actually has the file of the procedure. How is that information management regulated in the background? And that goes back to what I was saying earlier. Information management is becoming an ever more important part of things. For example, it's extremely difficult for horizontal composite procedures to work if only one administration knows what's going on and the others are not. It's very difficult for European level to intervene if it doesn't have the full file or sufficient knowledge of the file. And these issues are definitely very practical, but very, very important procedural issues if we want to make sure that composite procedures actually work and supervision in the end is possible.
Thank you so much, Hervé, for your very timely intervention, because in fact you are already anticipating what's going to be the content of the second presentation. So I give the floor now to Dr. Lisette Mustert, who's Assistant Professor of Administrative Law at the Utrecht University. Precisely, we are going to be speaking about the GDPR procedural regulation, and you are going to detain us, if I use that word, on precisely on the remedial aspects as they triggered by GDPR. So thank you very much. Welcome, and the floor is yours.
Yes, thank you very much also for the invitation to present here. I am indeed going to speak about two key challenges that I see for the administration, particularly in our digital society. And that relates both to the protection of fundamental rights through administrative legal remedies or non-judicial remedies, and to a problem connected to that, the functioning of these procedures within a composite administration, or an integrated administration, or hybrid administration. I think all words that we've been using today. So as regards the non-judicial remedies, you see in the Digital Act adopted since the GDPR, and that is also true for the AI Act, the Data Governance Act, the Digital Services Act, that in those acts there is actually a shift to the use of non-judicial remedies, particularly in the form of complaint procedures. So the right to complain before an administrative authority to seek protection of your fundamental rights, so the right to privacy or personal data protection, for example. And this discussion was very apparent in the GDPR negotiations, where you saw that under the Data Protection Directive, you had a possibility to submit a claim with a data protection authority, and the data protection authority was required to hear such a complaint. And the Commission then argued that because civil court proceedings are so difficult in the digital sector, because of the high costs related to it, but also the power imbalance between large data processing companies and individuals, there was a need for swift, speedy, also cheap procedures before an impartial forum, and that would then be a data protection authority. And therefore, under the GDPR, you saw a conscious swift to non-judicial remedies before data protection authorities via a right to complain and a duty for data protection authorities to handle that complaint. So this complaint procedure under the GDPR is now up and running for 7 years. And I think it shows very valuable insight into how such a complaint procedure is supposed to function, but also not yet functioning well in practice. And that is a question that the EU legislator, or concern that the EU legislator is at this very moment also struggling with, because the GDPR procedural regulation intends to streamline complaint handling. Although you see there that the problem with this procedure is that it is very much approached as a traditional investigatory procedure, an enforcement procedure, that at the same time needs to have a function of a legal remedy, which seems apparently hard to integrate. And I think that is particularly true because member states, because that is actually reflecting member states' practices at this very moment. So I've been looking into 5 different member states as to how complaint procedures are functioning before data protection authorities. And what we see there is that data protection authorities approach them as this traditional investigatory approach. So when a complaint is being received, they apply their usual prioritization criteria, meaning that only systemic or very serious breaches are being lifted to a formal investigation, and all other complaints, which might not have a systemic nature but are nevertheless important for an individual alone, are either not handled at all or being informally handled via, well, if you're lucky, a settlement procedure where you might be involved as an individual. But if you're unlucky, a data protection authority may simply resolve your complaint via a telephone call to the controller or a processor, solving your complaint, of which you are then informed as an individual. But that means also that such complaints are then being resolved or seen as being withdrawn meaning that your complaint does not end with a legally binding decision, which you can then also not challenge in court if you are dissatisfied with the outcome. But even if your complaint is being moved to the formal investigation stage, you see that complainants have actually a very old position in their own complaint procedure, because in many member states, they are not even recognized as a formal party to the procedure. So you are a third party to your own complaint procedure, meaning that, and that is the investigatory nature of the procedure, that the Data Protection Authority engages in a procedure with the controller or processor, but not with the complainant. And a consequence of that is that a complainant is often not involved throughout the procedure, but only at the end of it, when there is an adverse effect for a complainant. So when your complaint is being dismissed or rejected at the end of an investigation, you are being heard as a complainant. And obviously, there are differences among the member states. There are member states that recognize a complainant as a party, but this is rather the exception, I would say, and it also means that there is inequality among the member states. So when you are not being involved as a complainant in the procedure, this has large consequences, not only as a complainant for your procedural rights, but also, as Professor Hofman already mentioned, for the carefulness and the diligence within an enforcement procedure. And that actually follows from the umbrella principle of good administration, which is developed by the Court of Justice case law, of course also codified in Article 41 of the Charter, but that provision is only applicable to the EU institutions, offices, bodies and agencies, and not to the member states. But luckily, we have the general principle of EU law, which is applicable to the member states when they act within the scope of EU law, and which forms a very important framework and actually a ticket for individuals to a complaint procedure, not only to be involved and protected, but also to make sure that data is collected in a careful manner, for which complainants can provide actually very valuable input. The problem, however, is that this framework of impartial, careful decision-making, reasoned decision-making, the right to be heard, the right to access the file, is very nicely and in rather detail developed by the court, but that is not necessarily what member state authorities apply when a complaint is lodged to them. So member states, they apply their own national procedures, principles that are developed by member states courts, and that means that we have this framework, but in practice it doesn't work so easily through in the member states. But we see this problem being recognized in the sense that there was awareness in the Commission proposal that the complaint procedure needs an upgrade to function better. But in the Commission proposal, and unfortunately also in the discussions with the EU Parliament and the Council of the EU, we see that this investigatory nature is still reflected, even more and more complex, because that is actually the second problem of complaint procedures in the digitalized world, that violations often cross borders. And the GDPR establishes a very complex framework for that, not only of authorities allowing to access evidence in another member state via a mutual assistance request or joint operations, but also establishing a system for peer pressure among authorities. So when a violation affects individuals in various member states, all authorities of that member state are involved in the procedure, with one authority taking the lead. But eventually, the aim is that they find consensus on the outcome of the decision-making process. Well, that is complex in itself, for instance, because the lead authority will have a better position in the sense of access to information. It is a sort of gatekeeper of the file. And while those processes were also supposed to be addressed by the procedural regulation, we see now that the draft agreement seems to move to a highly detailed process where every step is being defined, but also not entirely. So national procedures will still remain in place and then somehow have to be integrated within this EU framework that is now being established. And while we know that procedural rights of complainants and the role of complainants is already complex in one member state, it is of course increasingly complex in such cooperation procedures where responsibilities blur, where it is perhaps unclear where to complain best, who is then responsible for procedural rights of complainants, who will adopt the final decision, how a complainant can access information when it lodges a complaint with an authority that is not the lead, while another authority is actually the gatekeeper of the file. That were all aspects that need to be addressed in a procedural regulation, which is unfortunately going in the direction of complexifying it without offering concrete solutions. And that is, I think, a pity, because this could have been a very good opportunity for the EU institutions to think how you want to shape a non-judicial remedy, and it could function as a blueprint for all the other acts that are now embedding the right to complain for individuals regarding fundamental rights, because that is actually at stake here. So I'm afraid that this is going to be a missed opportunity and remains a very big challenge in the coming years.
Okay.
Thank you.
Thank you very much, Professor Mustad. But you know, this is at the stage of a proposal, so
Yes.
you know, we still can resort to hope. But your focus is quite gloomy,
Yes.
so
Yeah, I'm afraid they're already quite
yeah,
far in
yeah,
reaching an
yeah.
agreement.
This is quite sorry, because we have been insisting that in order to come back to this diversity of procedures,
Yeah.
we would need the attention of the legislator. But
Mhm.
then you are saying that this, in this particular case, it will not be serving as a blueprint for future
I'm afraid not.
remedial procedures. Okay, hopefully, so again, we are still at the status of first reading, if I'm wrong.
First reading, but
First
there
reading.
might be an agreement.
Yeah, so let's keep our
Yes.
fingers crossed, and let's see what happens when the final outcome is adopted. Now we follow the same methodology. I turn my attention to you, distinguished participants. Otherwise, we will be referring or giving the word to our distinguished panelists here in the room in Maastricht. So questions, maybe in the chat pad, etc. Beatrice, there are no questions. There are two questions. Okay, so please.
The first one is, you mentioned that in administrative procedures, complaints often lack recognition as parties, which denies them procedural rights such as access to files and the right to be heard. Considering the ongoing trialogue negotiations on the GDPR procedural regulation, how do you assess the proposed measures to address this imbalance? Do you believe these measures adequately ensure the effective protection of fundamental rights?
I'm afraid not. And that is because these, the proposal and also the direction of the discussion seems to embed national procedures rather than offering more, the normative framework, also the framework that we can derive from the Court of Justice, so to say. So what you see is that there is the idea that procedural rights for complainants mostly come into play at the end of a procedure. For instance, an early resolution procedure, there is sort of an agreement that it would be enough simply to let a complainant object at the end of a procedure whether he or she agrees with the outcome of the settlement. But that means that you're not involved throughout the procedure, posing risk to the diligence and the carefulness of the investigation. And also what you see, particularly with formal investigations, is that there is a strong link to an adverse effect. So apparently a data protection authority will have to assess whether a complainant is negatively affected before procedural rights are being triggered. But we know from the court's case law that the adversely affected requirement is very difficult to interpret. There are very different standards applied as to how negative the effect must be upon someone. And we see specifically in the area of data protection many examples where it takes a very, very long time before there's finally an agreement upon whether you are adversely affected or not. And that is also because simply dismissing or rejecting a complaint is not the only way in which you can be negatively affected. It's not so black and white. So it can also be, and that is what happens quite often, that your complaint is only partially being handled. meaning that perhaps an authority actually acts upon your complaint. But when you believe that either the complaint was misunderstood or not every aspect of it has been handled, that you might still be dissatisfied with the outcome, but not being heard because action was taken. So I think that are very worrisome developments that are now seemingly being embedded in hard law.
Thank you so much, Professor Muster. But Beatrice, you said that there was another question, or
Yeah.
am I right?
We have one on the balancing efficiency and rights protection. So someone asked, while harmonizing procedural rules aims to streamline processes, there is a concern that these may lead to an overly administrative focus, potentially sidelining the substantive rights of individuals. How can the EU ensure that efforts to harmonize and expedite procedures do not compromise the fundamental rights of data subjects?
Well, I would say that a higher level of procedural protection would never have negative effects on the fundamental rights protection after all. Of course, if it means that procedures are getting lengthy and cumbersome and therefore very slow, that is a risk, of course, but that is I think also a choice of how you want to shape administrative procedures. And what you see now is that it is very detailed and every step is being spelled out with strict deadlines to each step connected, meaning also that there is no time, for instance, to correct errors or to respond to another party. And that is simply, I think, also looking for inspiration in the member states, where you see, for instance, in Austria and Belgium, that when hearings are being organized, that simply everyone is invited, there's a hearing taking place, everyone can respond to each other, and that's it. But at least you had the opportunity. Whereas in Ireland, for example, all these steps are being spelled out, one can respond to one another, and that happens over and over again on the scope of the investigation, the investigative reports, the preliminary draft, a draft to a draft. So it are choices to be made, of course, but and of course it is a balancing exercise between efficiency and procedural rights protection. But member states show a wealth of inspiration of how to organize such things. So
thank you, Professor Muster, for being so responsive to our participants, which have been quite inquisitive with the questions I see. Now we're going to change completely the subject. We move from your general introduction, Professor Reni Antonio, from GDPR procedural regulation. Now we're going to be speaking about another possibility to investigate instances of maladministration, which is the investigations which are conducted by the European Ombudsman. And now we're going to put these investigations of the European Ombudsman in context, because we are going, our speaker is going to focus on these investigations as they apply to the artificial intelligence, and also the investigations that relate to any type of issue related to the transparency of decision-making procedures at EU level. In order to enlighten us on this, again, very fascinating subject, and I have to insist that she speaks on her personal capacity, we have Dr. Tanya Ehed, who's an inquiries coordinator at the European Ombudsman and also visiting professor at the College of Europe. So welcome, the floor is yours.
Yes, thank you very much also to you, Diego, and to Florin for the invitation. So although I speak in my personal capacity, I will share some reflections on the European Ombudsman as a review and redress mechanism after we have, as you said, already heard about judicial and then other non-judicial remedies. So, and this reflection is probably particularly timely because, as you may know, a new ombudsman, a new European ombudsman was elected in December and took office a bit more than a month ago now. So I think it's very timely to discuss the role. So the role of the ombudsman is, as you know, set out in the EU treaties. It is to investigate complaints about maladministration in the activities of the EU institutions, bodies, offices, and agencies. And based on the ombudsman's investigations, he or she can make recommendations which are non-binding. And in this context, the ombudsman may, of course, be sometimes perceived as being in a position of relative weakness, so to say, especially if compared to the EU courts. But at the same time, and this is what I would try to argue, it is exactly this soft power of the ombudsman and the mandate to investigate maladministration that enable the ombudsman to play an oversight role in situations that are very difficult to address via other accountability mechanisms. And this role of the ombudsman appears particularly relevant in the current challenges we are facing in view of the rapid technological changes, but also political shifts. And I will try to explain why. For that, it is key to understand how, so based on what standards and principles the ombudsman fulfills its role of investigating maladministration. And as you may know, there's no definition of maladministration. So neither in the treaties nor in the statute on the ombudsman. So what does maladministration thus entail? I think in this respect, it is always useful to go back to the very first annual report of the first European Ombudsman for the year 1995, where he said that there's clearly maladministration if a community institution or body fails to act in accordance with the law. But there are many other things that can also amount to maladministration, and the report at the time gave a few examples, such as administrative irregularities or avoidable delays or lack of information. And this list in the report of 1995 then concluded as follows. It said that the experience of national ombudsmen shows that it's better not to attempt a rigid definition of what may constitute maladministration, and that the open-ended nature of the term is one of the things that distinguishes the role of the ombudsman from that of a judge. And I think experience now, after 30 years, has shown that the open-ended nature of the concept of maladministration has allowed the ombudsman to ensure that the EU administration acts not only in accordance with the law, but also in accordance with the broader and far-reaching principles of good administration. I think it is very important to keep in mind that maladministration can occur in any administrative activity of the EU institutions, which means, for example, that it is not dependent on the existence of a reviewable act. So the ombudsman can therefore investigate the administration's behavior in the development of soft law, in the formulation of new policies, or also an institution's activities before it has adopted a reviewable act. And what is more, the ombudsman can act in the absence of a complaint because she has own initiative inquiry powers under the treaties. So I will try to illustrate this rather unique position of the ombudsman, in particular in view of current challenges based on two examples. And the first example concerns the development and use of AI systems by the EU administration. And I think it has already become clear in Melanie Fink's presentation this morning that the rapid developments resulting from AI will have enormous implications for public administrations, but at the same time, there are also important challenges that AI poses. And it is therefore very important to ensure accountability in how decisions to introduce AI systems are taken and are then implemented. We know that most of the AI Act's substantive requirements, such as the obligation to carry out a prior fundamental rights impact assessment, apply or will apply to so-called high-risk AI systems only. But at the same time, it appears that at least some of the AI systems that are currently being developed or used in the EU administration would not fall under this category of high-risk AI systems. In January last year, the Commission published its communication on artificial intelligence in the European Commission, in which it set out its approach to AI in preparation of the AI Act, which was not yet adopted at the time. But the communication also listed examples of AI systems that the Commission is already using or is currently developing or intends to develop in the future. And it was against this background that the Ombudsman then wrote to the Commission in March last year, so still before the adoption of the AI Act, to gather more detailed information about the Commission's practice and plans to use AI in its decision-making. And the Ombudsman was particularly interested in the transparency of and public participation in the Commission's decisions to develop and use 3 specific AI systems that the Commission had listed in its communication. And these were AI systems concerning the analysis of feedback from the public, the management of competition cases, and a third one that concerns the handling of infringement complaints. And the Ombudsman chose these 3 specific AI systems because she considered that they might have a direct impact on the right to good administration by influencing how the Commission interacts with and takes decisions towards individuals, companies, and organizations. So what the Ombudsman did is that she asked questions about the specific functionalities of these tools, and general risks to good administration that can result from their use. She also asked about the procedure for deciding on the use of these tools, the transparency of this procedure, the involvement of stakeholders from outside the EU administration, and she also asked about the human oversight of these tools. The Commission then provided a rather detailed reply to the Ombudsman's questions, and if you're interested, I invite you to look this up. It is published on the Ombudsman's website. But when closing this case, the Ombudsman really tried to set the scene also for its role in overseeing the use of AI systems, and she shared some general observations on the AI Act and the principles of good administration. So she said that in its use of AI systems to support, in particular, decision-making, complaint handling, and other interactions with the public, the Commission is bound to uphold the principles of good administration, regardless of whether the requirements of the AI Act apply to those systems. And in this context, the Ombudsman has an important role in monitoring and ensuring that the introduction and use of especially low-risk, so to say, AI systems by the EU administration takes place in line with the principles of good administration, so that it takes place in a transparent, fair, and accountable manner. And in this sense, the Ombudsman then complements the role of the European Data Protection Supervisor, which is the authority responsible for supervising the compliance of high-risk AI systems with the AI Act, and of course that of the EU courts. The second example, if possible, that I would like to mention, and where I think the Ombudsman has a rather unique role to fulfill, is in monitoring compliance with self-imposed standards. And these include rules that are meant to make decision-making processes more transparent and participatory, such as the Commission's better regulation guidelines. And demonstrating that the EU administration is committed to uphold these standards is key to maintain public trust in the EU institution. And this arguably becomes even more important in the current context of multiple crises, where more and more legislation is adopted in fast-track or emergency procedures. So what can the Ombudsman do? So the Ombudsman can look into how the Commission applies such rules or justifies its departure from such rules, independent of whether the relevant act has already been adopted or will actually be adopted. And the Ombudsman recently received several complaints in relation to this, two concerning the absence of an impact assessment in the adoption of 3 legislative proposals. One legislative proposal is relating to an amendment of the Common Agricultural Policy in view of the farmers' protests of last year, which we all remember. And then 2 on the countering of migrant smuggling, and these latter acts have not yet been adopted. So in one of these cases, the Ombudsman opened an inquiry into how the Commission applies its better regulation guidelines when preparing legislative proposals that it deems to be urgent. And the Ombudsman asked in particular how the Commission determines and justifies urgencies of legislative proposals, whether it has any internal procedures in place for deciding on whether to derogate from the impact assessment requirement, how such decisions are taken and by whom. And the Ombudsman also asked how the Commission ensures, in respect of such urgent legislative proposals, that it still observes the principle of evidence-based decision-making. And then there is another case in which the Ombudsman opened an inquiry, and this concerns how the Commission carried out a targeted data collection on the impact of the wolf population in the European Union, because there the complainant also argued that this was not done in compliance with the Commission's rules on stakeholder and public consultations. So I think what this shows is that the Ombudsman can review how the Commission justifies its departure from rules that it has actually established for itself, and that the Ombudsman can play an important role of verifying that such decisions are not taken arbitrarily, but are based on evidence to justify the acts in each case. So I hope that I did not take too much time.
You're perfectly right. Thank you very much. Again, a very interesting and insightful presentation on the role of the European Ombudsman in a situation or amid a situation of technological change, as the one triggered by artificial intelligence. And from your presentation, I would retain a number of keywords, such as, for example, the situation of the fast-track procedures, for example. So therefore, I would invite either the participants or the panelists to dwell upon what you have said in order to pose the questions to you. So voila. So I turn my attention again to the chat part, to the participants, otherwise to the distinguished panelists. I look around, please, Professor.
Yeah. I have a question concerning how the Ombudsman goes about situations of technical, scientific complexity, because we know that the Court of Justice is rather hands-off with this kind of situation where a non-technical specialist would not easily understand the underlying substance of the question at stake. The Ombudsman is also equally lay in that sense and is not equipped with the necessary knowledge. So do you see that there is or could be or perhaps should be an evolution because the Ombudsman is in a way freer than the court in terms of mandate, etc., that they could avail themselves of maybe technical specialists or, trying to understand better what is the underlying, scientific technical problem in the situation, such as the AI, but it could be in other areas also.
Yeah, thank you. So I think in this respect, it is first of all important to mention that we cannot look into the substance of legislation. So we cannot really look into the political decision-making, so to say. What we can do is we can look into the administrative activity of the institutions. So we would always look into the procedures. So how particular acts were drafted, what was the transparency, the involvement of stakeholders, was everyone heard? But the problem, of course, is that it's a fine line between what is still procedural and where we enter into the substance, because you often need to understand the substance in order to see whether the procedure was correctly done. And there, of course, it can be very challenging for a small office of that, the Ombudsman, which I think we are 75 people currently working there. And we have, for example, currently a very complex inquiry ongoing into the delays in the authorization of chemicals under the REACH regulation. Still looking, of course, at the procedures, so to say, but there also we received, we opened this inquiry actually following a public consultation where we had asked for input from stakeholders to flag certain issues. And based on that, we then opened, and also during the procedure, we received spontaneous submissions actually from parties affected by this procedure to give us input and feedback also on the preliminary conclusions that we had reached. So yeah, it is indeed a challenge also for us then to look into these things. Yeah.
Thank you. Any further questions for the chat?
Yeah, we do have 2 questions. I don't know if we have time for both. I'll start with one. So the first one, the first one is on defining maladministration. So someone asked, given that the term maladministration lacks a formal definition in the EU treaties or the Ombudsman statute, how does this ambiguity impact the consistency and predictability of the EU's investigations? Would you advocate for a more precise definition to enhance legal clarity? Or do you believe the current flexibility better serves the ombudsman oversight function?
Yeah, I think it's a very interesting question because there were attempts made in the recent, not so recent anymore, 2 or 3 years ago, revision of the Ombudsman statute to actually include a definition of maladministration. It did not happen. And I think we are quite happy with that because indeed, so of course, it includes legality and compliance with the law, so that is clear. But then when it comes to the principles of good administration, I think this flexibility allows the ombudsman to really look into the individual circumstances and facts of a particular case and to really feel also a bit, was the threshold of maladministration really met or not? Were there efforts also made by the administration to accommodate the individual or other complainant? And although then something might still have gone wrong, but I think it's very useful to have this flexible definition. So if you ask me personally, I would be happy to keep it like this.
Okay. And you said that there was still an extra question from the audience.
Yes, the other one is on transparency and fast-track legislative procedures. So the question is, with the increasing use of fast-track or emergency procedures in legislative processes, how does the European Ombudsman ensure that such expedited decision-making remains transparent and participatory? Could you provide examples where the Ombudsman has intervened to upload these principles during accelerated legislative action?
Yeah, I think the 2 ongoing cases that I mentioned are exactly about this. So where we are trying to get some answers from the Commission of how it justified this departure from its standard rules, and really for us also to understand how these decisions are taken. I think it's very crucial that it's justified externally, but also that it's properly justified internally as well. But these inquiries are still ongoing, so I cannot really at this point comment on them further.
Maybe do we have the time for another last question? I would say so. Therefore, yes, I see that there is the chat bar popping up again. So now you have we have to refer ourselves to the computer. So Beatrice, could you read out the question?
Yes, of course. So Laura is asking, on what concerns complaints relative to handling of access to documents request? How can you find the line between procedural and substantive rules? And how far can the Ombudsman assessment go on the way the 3 exceptions under access to documents requests have been applied?
Yes, so I did not talk about access to documents, but this is a very big share of the complaints that the Ombudsman receives. I think last year it was 40% of our inquiries concerning access to documents. And the Ombudsman is a formal redress mechanism under the applicable legislation, Regulation 1049. And what we do in these cases is that we always inspect the documents that are at stake and then see what the arguments of the institution was in the final decision, in the confirmatory decision. And we would see, depending on the exception used, whether the assessment that the institution has done was reasonable. This often requires us actually to meet with the institution and to really hear their point of view and to get background as well on the specific subject matter, because it can of course be anything that the EU institutions are involved in. To clarify and to understand, and often we then also receive further confidential information that we cannot share with the complainant, but which can help us in our assessment and whether we agree with the institution's position. So there, of course, we have to go into the substance. Yeah.
So you have another question?
Indeed, this is a fine line that is crossed so many times because I was also a victim of such cases. And then you admit that you go to the substance where.
Yeah, but this is an administrative decision. No, it's not legislation. So that there, of course, we can review confirmatory decisions. Yes.
Maybe I can allow myself to question, because so far I've been just playing the role of moderator. So far, we have been insisting on the role or the necessity to have the legislator in order to come up with a codification of procedures. Now we have these investigations from the European Ombudsman that, the result, they lack teeth. So because they are purely, you have your annual report, and then it reaches in the, to what extent there's a communication between the Ombudsman and the legislator, so that these recommendations, which are presented by the European Ombudsman, can be translated into a proposal for amendments into ongoing decision-making procedures. To what extent the European Ombudsman and the plenary and the MPs are conversant? Mm-hmm. Or is the annual report something that is published and then it ends up in a drawer?
Yeah, no, I think so. It's also here again a fine line. So we have, of course, to be careful not to be perceived as interfering in the legislative process. Not that we can. Evidently. So that we cannot do. But when we discover things that or loopholes, so to say, or gaps or inconsistencies in legislation, which happen sometimes during our inquiries, what we would do is that we would flag this. And we have then brought these issues to the attention of the legislator. So we have sent our decisions to Parliament, or mostly to Parliament actually, for information, flagging that in our view there seems to be an issue that we cannot address. And then when it comes to our inquiries where we find maladministration and we see that there's not enough cooperation from the institution concerned, there's always this last resort of actually making a special report to the European Parliament, where we formally ask the European Parliament to support our recommendations, and the Parliament would then normally adopt a resolution on this, supporting the Ombudsman's findings.
Thank you so much.
Which point?
Yes, please.
I'd like, because it's very interesting discussing, back to the discussion on non-judicial administrative remedies and review mechanisms. And here, of course, my curiosity would be, in how far, does the European Ombudsman procedures, this kind of complaint, but also, self kind of initiative mechanisms reflect this kind of discussion? I mean, what would be the European Ombudsman? To what extent is it a mere administrative legal review? And to what extent can it play the role of, let's say, a legal remedy for the individual? Is that, what is your view on that? Just curious.
You mean in terms of how we conduct inquiries,
or basically, offering this kind of, let's say, a legal remedy to the individual, offering basically possible redress, let's say, to breach of the fundamental rights of the individual. Mm-hmm. Does the European Ombudsman actually play such a role, or is just in the end a mere administrative review mechanism, which of course can be triggered also by initiative, by individual complaints, but actually it does not work properly as the legal remedy to the individual? What would be your view on this?
Yeah. So I think there are really two roles of the Ombudsman. No? The one is to provide individual redress, and then the other is to really enhance the systemic issues in the EU administration. And I think we have very different types of complaints, but we do get complaints from individuals that have a very concrete problem with the EU administration. And often when we then look at it and there's a solution to this. So we can then also provide at a very early stage, after opening an inquiry, we can, give like a little hint, like there seems to be an easy solution to this problem. Could you implement it? And depending on the area, because it's very diverse, but in certain areas, the institutions are very responsive to this because it's something that they might have not noticed, or just an independent or, fresh look, fresh pair of eyes coming in can be very helpful. And then it can be a very quick redress mechanisms for individuals. But of course, there's always that if the institution does not agree, what we are saying is non-binding. So that always remains, yeah.
Dr. Regnes, we are not going to liberate you yet because this is still another question.
Well, no, it's not so much a question. It's a follow-up also to Diego, to the point you were making before. There's also been a lot of academic research carried out on the success of the ombudsman, despite the non-binding powers. And it has been shown that it is pretty successful through the power of persuasion. And sometimes, even if administratively it looks like no room for further, or no need for further inquiry or for further action, that's a bit what I think Tanya was just hinting at. If a solution is quickly found, or the Commission changes the systemic problem, it seems that nothing has happened, but in fact, something has happened. So in that sense, I think one should, and we maybe as lawyers, we like binding, yeah? It's more tangible, but I think one should not underestimate also the kind of the soft power of the ombudsman in that sense.
Yeah, right. I don't know whether you want to compliment, I suppose.
I absolutely agree with Magdalena. How could I know?
I figure I should make this point because I don't work for the ombudsman. So.
Okay.
Yeah, but maybe just to add on that, what we sometimes also see is that even if an institution originally comes back saying that no, everything was fine, so to say, we do then see change over time. So it's of course always difficult in this instance immediately to admit, oh yes, there was maladministration, we have done it wrong. But what we then sometimes see is that change is happening over time, and they would not do the same the next time around.
Mm-hmm.
But this is difficult to monitor, of course.
Mm-hmm.
So yeah.
Okay, thank you so much. Then you're finally liberated until, the final debate, evidently. And now we stay with the same institution who works with the European Ombudsman, which is the European Parliament. We're going to be speaking to you, well, not me, but our distinguished speaker is going to speak to you about the right to petition, which, as you're aware of, is spelled out in Article 277 of the Treaty on the Functioning of the European Union. And as you all know, this is a right which is enable us, citizens or residents in the European Union, to flag to the European Parliament, evidently, any situation of misapplication of EU law. The thing is that this right to petition is also a vehicle to precisely to flag to the European Union, to the European Parliament, instances of maladministration. So in order to enlighten us how this right to petition is handled in practice by the European Parliament, and to what extent the European Parliament in handling this right observes these procedural warrantings, it is my great pleasure to introduce you all Ms. Karin Pieghi, which works as administrator at the European Parliament, and I suppose that you also speak on your own personal capacity. Okay, welcome.
Thanks a lot for the invitation. Indeed, yes, I'm going to illustrate a bit the discussion we've been having today since this morning with this particular example of the right to petition. Just a few preliminary remarks about the Committee on Petitions. It's a non-legislative committee, so we've been discussing about legislation, etc., since this morning, and we do not. PETI, let's call it PETI, does not deal with legislation, but more on with the implementation, and it's the sole activity, the implementation of this right to petition, and this makes it particular inside Parliament, but also for citizens, for the petitioners. And there's this relationship between the institution and the citizens, which is at the heart of the committee and of the activity of PETI. And indeed, one of the main tasks, let's say, is that, well, petitions is a great tool to oversee the application of the legislation and how it's been implemented in the member states. So it's a very useful tool. So I will briefly divide my presentation in 2 points. So first part, I will make a brief overview of the procedural rights that benefit to citizens through the procedure of petitions. And then in the second part, I will specifically focus on the involvement of various actors in the treatment of petitions, which is a specificity for petitions, and also pointing to the challenges that it brings. Right. So the right to petition indeed is provided for in the Treaty on the Functioning of the European Union, also in the Charter of Fundamental Rights. The treaty only is very brief. It first of all give the right to petition the European Parliament. So we understand it's the European Parliament that will be in charge of applying this right. And it also gives some criteria for admissibility of the petitions. But it does not go further than that, obviously, I would say. So the Parliament has drawn up rights, procedural rights. And first of all, in the rules of procedure in Title 9, there's a lot of articles dealing with petitions and the process of petitions. And also the Committee on Petitions provided guidelines which focus more on the cooperation with the other actors during the process. And then, so these rules give procedural rights, which are mainly based on, I would say, general principles of EU administrative law. These rights pertain to we were talking about good administration, the principle of good administration, and other rights, I would say, information-related rights like data protection, access to information. And I've put some of these rights that I will go through quickly. First of all, the right to be heard. Petitioners may be given the possibility to address, to express their view and to address Parliament in writing or orally. And in practice, they are invited to speak during committee meetings when their petition is debated. So they also have a possibility to participate in fact-finding visits that the committee organizes to establish facts or to seek solutions. The petitions are also provided the possibility to provide new information to be added to their case. And this is especially important when the Parliament intend to close the petition. Prior to this, we always tend to revert back to the petitioner and ask about his or her views and comments, and maybe to provide further information. Petitioners also have the right to access their file. There's a specific duty, which is the duty to state reasons for administrative decisions. This is particularly important because we always, when decide on a petition, petitioners are informed in writing of the reasons of the decision. They are provided with the relevant information and documentation, and it's particularly important when the committee decides on the admissibility of the petition, because there are two parts. The admissibility of the petitions, the committee follows the criteria set by in the treaty. So there is no scope for discretion, I would say, from the parliamentary side. And then when we have decision on the follow-up actions to be taken on the petition, this is, I would say, more a discretionary by the Commission, and there is no, let's say, there's sort of political discretion, and there is no ground for annulment of the decision. So there is a sort of judicial review for the admissibility decision, and no review or almost no review regarding the other decisions by the committee. Petitioners also benefit from information rights. They are informed at all stages of the procedure. They are about the decisions that are taken on their petition, and they are also provided with all the opinions the committee receives about the petition from the Commission, the European Commission, but also from other parliamentary committees, other EU institutions or bodies, even member states authorities. Petitioners also may use any of the EU languages when they communicate with the Parliament, and we also have to reply to the petitioners in the language of their choice, provided it's a EU official language. I also mentioned the duty of care, the duty to cooperate, which comes also with the reasonable limit given to the petitioners to reply to a request from the committee. Many others. I am looking at the clock. Duty to keep records, and also to the last two, respect for privacy and principle of transparency. These are very important, and in practice we see them a lot in the committee. Petitions are full of personal data, personal information, and so we have to treat them under the data protection rules. So data protection is very important to us, and also access to documents is important because Parliament is an open administration, and there is also transparency. So there we have these two parts of the question. It's whether we give transparency also concerning the data and the information that is provided in the petition, and also we have to protect personal privacy. So all these procedural rights provide guarantees to petitioners, and we have also to keep in mind that Parliament decisions are of political nature, and which, to my view, gives guarantees very important, because it's important for the petitioners, for the citizens to have a certain level of certainty, clarity, and predictability when it comes to their the decisions that are taken on their cases, and also we have the decisions by a political body, not when it comes to not to admissibility, but when it comes to the other decisions taken by the committee, which are of political nature and discretionary, I would say, by nature. I will then go quickly to the second point, which is the next slide, please. The involvement of various actors in the treatment of petitions. The guidelines, the petty guidelines I cite, say that the treatment of petitions should not be a matter exclusively for the Committee on Petitions, but a shared responsibility across the institution and together with others. And this is particularly true because petty always need the input from the specialist. So in that aspect, the European Commission is a key player for the petitions process. not always, but very often request the assistance from the Commission, especially when it comes to the application of the compliance of European law. The Commission always attend the PETI meetings, but we also may seek the information and the opinion of other stakeholders. I would say the important one is the member state, because when we talk about the application of EU law, it's very often matters of misapplication or non-application of EU law, of transposition and violation of EU law by a member state. So petitions, when a petition concerns the situation in a member state, member states are requested to provide their opinion and their assessment of the issues raised by the petitioner. And in this case, I would say the impact of a petition highly depends on cooperation, on that cooperation. If a member state, for example, does not reply or does not provide any element either to the Parliament or to the Commission, it's very difficult for the Parliament to really assess an alleged infringement of EU law and to reply to the petitioner properly, so in an adequate manner. And in this case, as Parliament has full discretion on the decision, on the ultimate decision on petitions, but has no, well, highly depends on cooperation. It's kind of a situation of shared responsibility on one side and exclusive accountability, which is sometimes a bit difficult to explain to the petitioner. And this is particularly relevant in cases of alleged infringement of EU law. And so I come to my very last point on the legal limit, which is the Commission's discretionary power to launch infringement procedures. And we were talking about this, we heard this morning about this strategic approach by the Commission, which gives priority to systemic shortcomings, excluding individual cases in general. So very often we have to reply to the petitioner that he raised a possible case of misapplication or violation of EU law, but it's an individual case which would be better handled at national level by the court, for example. And if this is, I mean, this practice from the Commission is clearly legal. It's been confirmed by the Commission, by the Court of Justice, and it's understandable from a really legal point of view. It's sometimes very difficult, as I said, to explain it to the petitioners, to the citizens, and it can also hinder the impact of the petition, because ultimately we do not do anything with the petition, with this problem that was raised and bring through to the Parliament. And ultimately it's been the whole process and the whole right of petition is sometimes perceived by the individuals, by the citizen, as unsatisfactory. And I think I will, well, I will stop there.
Thank you so much, Ms. Piaget. So indeed, a very interesting right. It's a mechanism of participatory democracy. In the handling of this right, we can see that there are a number of elements of this principle of good administration, which are indeed respective, such as accessibility, transparency, the right to be heard. But you doubt, or we can doubt, as per the effectiveness of this procedure, precisely due to the fact that sometimes, as you said, It depends very much on the cooperation of the other actors, the slow processing times in order to get to a final result, etc. We still have 5 minutes, and I would like, in my capacity of chair, to invite participants to formulate the last questions. And also during these 5 minutes, I would like to wrap up, and for that wrap up, I would like to invite my colleague Florin so that we can somehow conclude and close the seminar together. So thank you. But first of all, questions from your side. I don't know, Beatrice, you have been very attentive all throughout the day to the chat part, so probably there are questions also to Ms. Pieguet.
We have 2 quick questions. So one is, how does the Committee on Petitions coordinate with other parliamentary committees to address issues raised in petitions effectively?
So there are 2 ways of cooperation with other parliamentary committees. One is sending the petition for information. So right away when we receive the petition, we consider, the committee considers that it's interesting for the committees responsible for the subject matter to be informed of the issue raised by the committee, by the petitioner. And the other form is to request an opinion. So it's more formal, and so we expect from the opinion giving committee an opinion on the issue raised by the petitioner.
Thank you. And the second one is, what mechanisms are in place to ensure that petitions lead to tangible outcomes or policy changes within the EU framework?
Tricky one. You said legislative changes, did you?
Policy changes, outcomes or policy changes.
Again, it's linked to the first question because it's cooperation also with the internally with the other committee. So it's easy when we have a petition which point to a question or an issue which is currently being discussed by Parliament. For instance, when there is a current discussion on legislative proposal, then the petition is quite interesting, I would say, for the lead committee, we call it like this, because they can take it and use it for the policy making, and then it's a bit more complex, I would say. In other cases, I don't know if you want to be more specific or okay.
Thank you.
Thank you so much, Ms. Pieguet. So in my capacity of moderator, I don't want to add anything else. Thank you very much for your participation, all the participants, the distinguished panelists. I think there are no more questions, and we hardly have a couple of minutes, so therefore I would invite you, Florin, since you launched the event, so I would like to invite you to formally wrap it up.
So I'm not sure if there are further questions, also maybe among the speakers,
colleagues,
last questions.
We are stretching a little bit of time. No, sure. Otherwise,
from the chat regarding all. Okay, if not, then I think we are nicely on time. I think we still have about 2 minutes. I'm going to stand again, maybe to be more visible, or maybe just sit because I don't want to make any kind of difference in.
We are stand up all
exactly.
together.
We can stand up all together. So I'd like to thank everyone, starting with the speakers for this very interesting event. I think was a very nice discussion. I think a lot of insights, and it was our pleasure. It was also our intention to bring a bit, let's say, to join a bit the academic and the practical side into this event. So that's why we had this kind of composition, rather mixed composition of the panel. So having the academic world a bit, but also the practitioners world. Talking to each other and basically sharing views on these challenges and developments in EU administrative law. So thank you to all of you for your contributions, for your questions, for the exchanges, reactions, etc. So I think it was a really rich conversation or event, if you want, from which I think we have a lot of things to learn and to further use maybe in the upcoming EU administrative law modules that we're going to develop. So as I said, the idea was this is more or less, if you want, launching kind of platform for the upcoming EU administrative law modules. As I said, the first two will start most likely after summer, so towards fall, maybe end of the fall. And they will deal, I think, with, as I said, structures and procedures in new administrative law. So I think the idea of composite procedures, hybrid structures would be definitely one to be taken into account. And the other one will deal with the right to good administration and other procedural rights. So we had a lot of discussions about this in different contexts. So I think, very rich discussions, and I think. As I said, I think it was quite a rich and an insightful event. Maybe, just one last note. If you are interested, this is for the online audience in particular, except for Hedwig, of course. If you are interested in the upcoming modules on EU administrative law that we are going to develop later this year, please subscribe to our newsletter, because you receive more news about this. But also, and I know that among the online audience, there are a lot of practitioners, some of them from the EU institutions, some of them from national administrations. If you are interested in a tailored kind of, let's say, or more insights, and the idea of having tailored kind of, let's say, EU administrative law trainings in the near future, please also do not hesitate to get in touch with us directly, with me or Diego. I think you can find us very easily on the APA website. You have our email address. Perhaps we can also post the email addresses in the chat now for the participants. So in case you wish to have a bit of more insights, more information, and particular needs, for instance, regarding specific tailored training in EU administrative law, then please feel free to reach out to us. Then for the rest, I think, we are nicely on time. So again, thank you so much for being here, for sharing your views with us. Hopefully, we are going to meet again, on different occasions within the framework of this launching of the EU administrative law module. So I already hope to have various kind of contributions from some of the speakers, and that would be very nice, I think. And with all this, I think we can end up here and wish you all a very good rest of the day.